Okay, the door has been closed, I notice, so maybe we should go ahead and get started. I see that we have some new colleagues today. You maybe had obligations yesterday. We're glad to have you for this morning. I hope you'll be able to kind of catch up and figure out what we did yesterday, because in some ways we're building on what we did yesterday. So I apologize if not everything I talk about today seems to make sense, because you missed what we did yesterday. And I know there are a few people who were here yesterday who could not, please come in, who could not stay with us today. So I have several more demonstration classes planned today. Oh, thanks so much. Thanks very much. Appreciate that. That helps. Several more demonstration classes planned for today. But I actually wanted to start by asking those of you, there were many of you here that I saw who were at the forum, the public forum yesterday. How many were there? I know I saw 3 or 4 or 5 of you. Okay, yeah, got it. What were your thoughts? Did you find it useful? Did you find it too simple? Was it, what did you think about the interaction of the professor, the judges, me?
I think that yesterday the semester was really good because it's a combination of practical and theoretical experience. It's good.
Mm-hmm. Okay.
Issue.
Okay. Others, what did you think? Anybody?
In relation to the discussion later,
sure.
I think it was a little bit incoherent.
It was
incoherent.
Incoherent. Okay.
A little bit, but still, I think it might serve very good for people who don't know absolutely nothing about legal ethics, like students here from the university. I've seen many of them. And I think that it's good for them just as a first insight into into these issues.
Was it? I'm curious, because I'd like to kind of figure it out for future opportunities. Was it incoherent because people were talking about things that the audience didn't have enough foundation?
I think that the problem is that, or the problem might be that these, for example, these people, these judges from various courts are probably not so much interested in legal ethics teaching and legal ethics academically, so to say. So maybe this was the point. And also the languages, I don't know how was your translation, but
I was just getting whispers in my ear of everything that was said in Czech, and it was fine. I mean, actually the Ladislav, right? He did a great job. But what he was doing was the right thing to do. He was not trying to give me a literal word by word translation. He was giving me the essence of what someone was talking about, which is best for me, actually. It's easier for me than to hear in it some idea that I then want to comment on, rather than having to try to follow every word.
But still, I think it's very useful generally here at the university, because it may serve as some helpful thing to catch the interest of the students for these lessons of legal ethics.
Okay. Anybody else have any impressions from it? Were you there?
Yes. For me it was very interesting, but maybe too short, because there are many or more interesting questions that could be discussed.
Exactly. And if you had a chance, maybe you would ask some questions, right?
Maybe later.
No, but I mean, in that setting, you might have asked us questions, and we would have talked about things you would have been more interested in.
Yes.
Okay. And you can tell me what those things are, and I'll try to talk about them. Okay. Anybody else have any impression of it? I thought it was pretty good. I've done quite a lot of those in different places, sometimes surrounding professional ethics, sometimes surrounding more specific issues. The one yesterday was very general, very general. I did one, for example, in the last year in Bratislava that was about lawyers and judges, especially judges, interacting with media. So it's much more specific, right? And I think that sometimes means that fewer people will be interested in it, but it also means that there will be a lot more in depth on that particular topic if it's a narrow one like that, right? And so it's a trade. Good morning. It's sort of a trade in that way. And on that one we actually had two quite good judges, one of whom was the same one as yesterday, and a journalist and myself, and we were interacting around that issue. So okay, good. I'm glad that you found it interesting, and I learned from what you just said about part of it that maybe doesn't come across quite as well. We almost made it.
Okay.
So we were hoping for 3 more people in 3 more minutes. And we got the first 2 in 30 seconds. But we at least got our 3rd person. It's great. Thank you. I'm glad you could make it. All right, so I'm going to do a demonstration class now that is, in terms of professional ethics, is about the interaction and decision-making, joint decision-making between lawyer and client, which is an extremely important matter. Sometimes it gets too little attention, but essentially who should be empowered to decide what sort of things in the lawyer and client relationship. That's what this is about. But it's also about, as you'll see, a very thin line between helping your client do something that is unlawful and merely providing information with which your client may do something unlawful. And this is a very, very thin place that gets a lot of debate actually in the literature. A lot of scholarship has been written about this particular topic and what should be the decision-making process back and forth. So that's what we're going to talk about. And in the middle of this, some of you, I think, teach legal theory. Yeah? In the middle of this, there will be a legal theory aspect, and I'll ask you later if you kind of saw it, or if you saw it and think it's completely wrong, or it's a good one, or whatever it happens to be. But that's what I'm going to do now. So it's as if I've started a new class. Here you are, my students, again, like yesterday, and we'll see where we go with this. All right, so can we agree together that there has to be a norm that says that lawyers are not permitted to assist their clients in doing criminal or unlawful acts? Can we agree? Okay. How fast is a person allowed to go on the high-speed road between Bratislava and Brno? What is the speed limit?
110.
110.
In general,
130 is the posted speed limit?
Yes.
Okay, 130. And maybe in some places it's 110.
I think so.
Okay, I that's fine. In the States it's 70 miles an hour, sometimes 65, that kind of thing. But okay, we'll work with 130 as the limit. Have any of you in the room ever gone over 130 miles or kilometers per hour? Anybody? We won't tell outside the room, even though it's being recorded. Have you? Sometimes? Okay. Why do you do that? Why do you do it? You said you do. It's okay. I do too. So for what that's worth, I will relieve you of guilt.
For example, if you want to override someone,
You want to pass someone, yeah.
so pass someone,
Yeah.
you have to
Okay.
speed up.
Okay. Okay. Is that the only time that you go more than 130? No? It's not the only time? No? Sometimes you just want to get there sooner?
Yeah, you go to court hearings.
Yeah, just to get to your court. Okay,
And
so,
it's safe because nobody's there. So.
and no one is there maybe, the traffic is not much, so you think it's okay, and, okay. Now, imagine, this sounds improbable, but imagine with me, at least take this to be true. You have a client, a new client who is in your office, you're a lawyer, and they're there on some maybe important matter that you're working for them. But in the course of the conversation, they are like me. They are new to Czech Republic. And they say to you, how fast can I go on the high-speed road? What will you tell them? What will you tell them?
The rule says 130.
The rule is 130. Will you stop there and say no more?
Well, I don't think it's needed to.
You don't have to say any more. Would anyone say any more? You are very cautious people. Very afraid of risk, maybe. What if the person says, well, where I'm from, people often go faster than the posted sign. Is it possible here? Do people do it? Do you answer him?
Sometimes.
You would say, oh, sometimes you answer, or you say sometimes people go faster. Sometimes people go faster.
Yeah.
Ah, okay, okay. Is it safe to go faster?
Sometimes.
Sometimes. Will I be stopped by the police if I go 135?
Maybe.
Maybe?
Probably not.
Vita says no, probably
It's
not.
very limited.
Is there in the culture, in your knowledge of how police behave, right? You all know these things. I know them at home myself. I can tell you if you like to know. But here you know better than I do. I'm your client. I'm asking you. I'm new to Czech Republic. In the culture, is there a kind of understanding of how fast you can go before you are really at any risk of being stopped by police? Is there a number?
Well, sometimes you get stopped by, even if it's like 51 when 50 is the rule.
So you could get stopped even
It's
immediately
not,
over 130.
It's disputed whether it's even possible to enforce the penalty. So
Okay, people dispute whether it's even possible to say.
5 kilometers is usually
5 is okay. 5 more is okay.
on highway,
Maybe
even
more.
more.
Even 10 is more okay. So 140 you think. Okay. All right, now we may not all agree about that. Some of us think it's 135. Some of us think it's 132. Some of us think it's 140. But I think if you were not being videotaped, everybody in this room would pick some number higher than 130 and say, it is safe. It is safe. You will not be stopped, or even if you are stopped, it will not be enforced that way. Okay? Will you tell your client this information? Do you think it's different? You just told me. Are you afraid that I am now going to go out and break the law with the information you provided me?
It's your decision.
It's my decision. So you have just provided information. That will be your position.
Yeah.
I have provided him with information. If he decides to go and violate the 130, that is his choice. You will not be in my car, will you? Pressing the gas pedal. You will not be doing that. You have just given me information. And so you feel, I think you're saying, tell me if I'm wrong, you are not helping me break a law, do something unlawful by providing me this information. Do you agree?
Yeah.
Okay. So why won't you tell your client the same thing? You told me. Or will you tell your client? Will you say to your client, 130 will be the sign. You're new here. The sign will say 130. Everyone understands that it is very unlikely that you would be stopped unless you go more than 138 or some, whatever is the number for you. Would you say it?
Yeah.
You would say it. Okay. Anybody would not say it. Anybody would refrain from saying this because they are worried that they will induce the client to violate law. Okay.
I would say a bit more differently.
Okay.
I would say the rule is 130, and as you said, it's highly unlikely that you get stopped, but it's still possible.
Still possible. Okay, it's still possible.
Maybe I will add that I do not recommend him to.
Ah, yes, yeah. And you will put it in writing and have him sign it that you have not recommended this action. And, okay, you will be a very careful lawyer. There's nothing wrong with being a careful lawyer, by the way. I'm not criticizing it. I'm just comparing you to your colleagues who are less careful than that.
I think that these are two types of information. Information from a lawyer and information from member of society. You know.
And they're different somehow,
Yeah.
right? So you, however, are talking with a client,
Yeah.
and we've, in my hypothetical situation, right?
Yeah.
And you are maybe passing along what is general public knowledge
Yeah.
about how fast one may go safely without being stopped, or at least the chance of being stopped very, very small, right? But at the same time, you are a lawyer at that moment. You are talking with a client at that moment. And my question is, and you've answered it, I'm happy with your answer, it's fine. If you provide that information, you are not helping your client commit a crime or do unlawful conduct.
Okay.
You're satisfied with that. Just provide information.
Yes, I say the information by law, also law information. After that, I say some, how can I say it, culture information.
It's
or
cultural
social
information,
yeah. But I say that it is not rule. It's only his possibility, but
I
it's
understand.
wrong. But
Okay.
it's safety, maybe.
And yet, I want to distinguish between this cultural information and law information for purposes you'll see as my hypotheticals change in the next few moments. It's still about the enforcement of law, and after all, you are a lawyer. So maybe lawyers do know more about some such things than ordinary people, right? Especially if you do some criminal defense practice, let's say, and you have more experience with the police, and you have been in court on police cases involving traffic and things like that. Naturally, a client would respect your words and knowledge more, and they should, more than they would from their neighbor, right? Okay, all right. All right, so most of you seem comfortable to give this information. Maybe we would be more careful. Maybe we would have disclaimers and documents and so forth, But okay, we're there. All right, second hypothetical, and I apologize that a couple of these are specifically based on law in the U.S. And you may not have exactly the same law in Czech Republic, but I can promise you, having done this little class in about 10 countries, almost always people in the group say, well, we don't have that, but we have something else that's, that is an analogy to it. It's similar enough that we understand what you're getting at. Okay. Second one involves taxes. You like to pay taxes? You enjoy paying your taxes? Somebody told me today or yesterday is the deadline here. Is it true? Today is the deadline? And everybody has done their jobs, right? Everybody has paid their... Okay. And you have to fill out some document, I assume. Yeah? And is it possible, it is in the U.S., if not here, you'll analogize it to something else. Is it possible when you are calculating the amount of tax that you are obliged to pay for certain things to be deducted from your income, it's an income tax we're talking about, certain things can be lawfully deducted from your income before you calculate the tax. Correct? So it reduces your tax obligation. Okay. In the U.S., one of the things that is deducted are charitable contributions. So if I give money to some NGO, like Pro Bono Alliance, that does, I knew you would appreciate that, that does good public work and is recognized, you know, they have to have some kind of tax-exempt status with the state and so forth, I understand. But if I give money to that kind of organization, I'm allowed to deduct it, right? In the U.S., the Internal Revenue Service, you must have a ministry that's responsible for collecting the taxes and, you know, kind of policing those returns and everything. I'm sure you do. One of our presidential candidates right now says he will abolish the IRS, the Internal Revenue Service, soon, but we doubt it. Anyway, they make available to tax professionals, and tax professionals in the U.S. include lawyers who do tax work. They also include people who are not law trained, who do tax advising and things like that. Accountants can do it in some capacities and things like that. So people who know a lot about tax law and enforcement stay familiar with documents that the Internal Revenue Service actually publishes about its enforcement practices. Okay? Ordinary people could find them if they worked hard to find such things, but they would spend many, many hours and maybe never find the right thing, whereas a tax lawyer knows it like this. Okay, so we're there. You see why I was trying to get you to agree that the lawyer might know more sometimes than the layperson. You have a client, and he's doing his tax return, and it's the deadline today, maybe, and he asks you, how much is there some maximum of charitable contribution that is allowed? Okay? And what you know, because you keep up with these careful advisements from the Tax Revenue Service and the ministry here, you know that the tax service will not examine a tax return, look closely at it. It will just accept it, as long as the charitable contribution, for that purpose, there may be other problems with it, but for charitable contributions, they will not even look at it unless the charitable contribution number clicks in the computer to be more than 2% of your income, your gross income. Okay? So if it's under 2%, they don't look at it. They don't ask for documentation. They do nothing but let it go. Will you tell that to your client? It's okay as long as it's under 2% of your income. They don't check. They don't examine it.
I think I would tell the client,
You would tell this.
if I were informed of this
You know it,
of
yes.
practice, I think I would tell. But
Okay.
it's upon his or her responsibility and liability whether...
So it's like the car driving one. You can tell them that it's safe to go over 130 as long as you don't get behind the wheel and push down the gas pedal. As long as you, in this example, are not actually the one filling out the form and documenting it for the client, it's okay. You're just providing information. You're providing legal information about the enforcement of law. Jan?
I would add that it's not the law, but just a practice which may change every time. Just a practice.
Okay, so you would give some warning.
Yeah.
You are like your colleague here who will want to give some hesitation about it, but we would tell it.
Yeah.
You would say, as of today, as we sit here right this moment, the most recent information from the ministry is up to 2% of your income. They don't care.
Yeah, but I would add it's not the law. It's just a.
It's a practice. It's a practice of enforcement.
Yeah.
It's a practice of enforcement, essentially, right? And now, you said it's not the law. The legal theory people in the room right now are saying to themselves, Well, there are legal theorists who say that law is actually what the authorities decide to enforce, not just what is written in the book. So I accept that you say to the client it's not law. Some theorists will dispute that with you, but it's okay. We can settle on that for now. All right.
By the way,
Yeah.
is it defense in criminal case? Because at least according to Czechoslovakia, it's a crime if you would fraudulently say that you have given something to charity if it's not true. So
Oh, no, if you have fraudulently stated you gave more to charity than you really gave, it is a crime.
Okay.
No question about it. We're really talking about the enforcement pattern,
Yes.
if you will. Not that it somehow makes it lawful for everyone to claim charitable contributions of 2% of their income. That is not lawful to do that in that sense of the word. You're right. So is anybody afraid? Several of you have said, not all, have said, of course I will tell my client. I have legal knowledge about this. I have knowledge of how the ministry functions. And it's publicly available knowledge even for someone who looked hard enough. But I am the expert. That's why they ask me these questions. I should be able to charge a fee for giving information that I acquire as a professional person that lay people, ordinary people, don't usually have available to them easily. So, of course I will tell. Is anyone worried when you tell the client, like the client leaves your office after you've told them about this 2% safe zone, if you will, is anyone worried that the client will go home, fill out their tax document and state up to like 1.9999% of their income that they claim they have given charitable contributions when they have not? Anybody worried that they will do that?
No, I say him that he can do it, but I say him that it's if he do it, how can I say it, without good reason or right reason, he breaking the law.
Yeah. So you would say to him, they won't check.
Yeah.
But if it's not true, you are breaking the law.
Yeah.
But they won't catch you.
No, it's possible that
Right?
they can catch
Isn't
me.
that what you'll be saying that in so many words? I don't mean it, literally you will say those words. But in a way, you're saying that.
I do not recommend you to do that.
And you would say, I do not recommend that you do it. What would you say? Yeah, I do not recommend that you state more charitable contributions than you have truly made. That's the way you would say it. Something like that.
You have obligation to do it in the right way.
Okay?
Not to recommend, but it's
Okay.
not possibility.
But is anyone actually concerned at all? Are you concerned that you will, by giving this information, create additional law violations than would exist if you didn't give this information?
I don't think so. I think that I should say him every information. How can I call it, good and bad information, and it's on his decision
Yes,
what he make with this.
I understand that. You're not worried. I get what you're saying, that you're not concerned that you will be found responsible for what he does. I understand that. But are you concerned that the volume of law breaking will increase by a little bit if all the lawyers and tax advisors give this information out freely? Will it be true? I mean, empirically, will it be true, do you think, that somewhat more people will violate this law that says you have to be truthful when you give this information to the tax service than would violate it if they didn't know about a safe zone, if you will? What do you think?
I think that it's better if say it I to him, because he can ask to another person who can say him, yeah, do it because it's better to you.
Sure. He can get the information from somebody else.
I say him it in
We know he'll get it from your colleague right here. Right? He could just go right next door
Yeah?
and ask this guy.
But I say him
And
in
he will find out.
professional way. No.
Yeah, okay, so
Not
you
in interest.
okay.
Matter of competition.
Okay, so is no one is
I would not say I'm worried about it.
You're not worried about it.
I think the risk is there. I counted, but it's not up to me. So
Okay.
I'm not worried. I
Okay.
know it, but I trust the people will follow the regulations.
Okay, okay, so maybe my word used worry, you will not, you know, be hard falling asleep at night as a result, I understand. But you would agree with me, right, that by giving this information, empirically it's likely that we are increasing the number of people who will violate these norms.
Second.
Yeah, please.
I don't mean that he goes.
Oh, you've consulted your colleague.
I don't.
Aha!
I don't think that he go to another lawyer, but he can go to another businessman and he say,
Sure.
"Yeah, broke it because it's."
Oh, but lawyers won't tell him. Only other business people will. Ah, okay, okay, all right. I'm worried that there is going to be some restraint of trade between the two of you back there. There might be some competition problems with the two of you.
Absolutely.
Okay. I hear you collaborating back there. All right, so most of you are comfortable giving this information about the enforcement of the tax law. I think most agree that it might increase the number of people who misstate, intentionally even, their true charitable contributions, but it's not going to keep Vita up at night, at least. He's not going to have trouble sleeping or anything like that. And some of you will try to document it a little bit more carefully than some others. All right, this one might, here's the third one, okay? This one might be more uniquely American, but I think not also. I think there are some things like this, but not exactly the same. So there are some old laws passed by our state legislatures in some of our states. Many of them had these kind of laws in the past, but some of them still have never repealed or taken back these laws. So they are in the statute books, just like they would be an article in your code. These laws prohibit sexual relationship between unmarried people. It's a crime for there to be a sexual contact between unmarried people. And these laws are 70, 100 years old. But as I said, there are some states where they have never been actually taken away, but they're not enforced. I mean, there isn't enforcement, except, I will say, except for rare, very, very rare occasions when there has been a bad prosecutor, a kind of bad-hearted prosecutor who has used these kind of laws against homosexuals, for example, okay? So that happened just not too many years ago. Some prosecutor in some small town in some rural place, was charging these kind of crimes to certain people because he didn't like them, right? So these are very, very rarely enforced. It seems only enforced in bad faith, right? But it's still there. It's still an article in the code, if you will. Lovely young couple comes to your office. They are your age, middle of their 20s maybe, or something like that. Very nice young couple. They come in even with their 2-year-old daughter. She's very, very cute. So you know what they've been up to, the two. And they come to your office. They're not married. And they ask you to arrange the transfer sale of a house that they are going to live in together. Will you do it? This is an easy one? Is it just as easy as the 130 kilometer an hour example? Even easier, maybe? Is there anybody in the room who will not fill out help them buy the house because you believe you are facilitating their commission of a crime? Anybody? Nobody. Okay. In this instance, aren't you actually being more active in their violation of law than the two examples we've already done where you are merely providing data? You are merely providing information. In this one, you are actually arranging for the house where they will live together. You're more active, yes?
Yes, I'm more active, but I believe that the statute is unconstitutional.
Ah, wow.
At least in Europe, according to ECHR case law,
Okay.
it's not possible to
Okay.
crime.
Okay, so you need here to think of another old law that is still an article, that is rarely enforced, that is not violating an European Court of Justice or human rights case. If you work at it, you can think of one, I think. At least I've had that experience. Most people have been able to think of some old criminal law that is never enforced. Are there any such things in?
We have a quite new criminal code.
You have a very new criminal code. Okay, all right. Well, then maybe it's not possible. All right. You are all comfortable, even if you're American lawyers, with the fact pattern I gave you. You are all very comfortable doing this. Even though you agree, you are somewhat more active in this aspect than in the first two instances. Is it because you think this article is not law? I know you said you think it's unconstitutional. Maybe it is, maybe it isn't.
I think that it's not law in this actual society. Well,
It's not in this society.
Yeah.
Okay, so it does not reflect current norms of behavior.
Yeah.
That's for sure. Gee, can't there be some other ones? We, for example, maybe we're the only ones who ever did these stupid things on Earth. I don't know. We used to have laws against people making their own alcohol. We had laws against people making their own alcohol at one time, and I suppose there are probably such laws in a few states that have never been taken away. I mean, you must have something like that, even if your criminal code is new. All right. Even though a written law on the books doesn't reflect current societal norms, does that mean it's not law? Does that mean you're not helping them break a law? Where are the legal theory people here? They're not going to speak. All right, I accept it.
And
You're all
there
comfortable.
is not in the general law of United States some legislation of this issue.
No. This is a state-by-state kind of thing, right? Most of our criminal law, not all of it, but the vast majority of our criminal law, if it does not affect interstate movement or commerce, okay, those are what become federal criminal laws. The ones that affect interstate, going from state to state somehow, or crimes that somehow cross state lines. So things like kidnapping of a person who could easily be picked up and carried over someplace else. That's a federal criminal statute. But this kind of law, which involves very private conduct that takes place in a single location, is certainly not a federal kind of interest criminal law. It's a state sort of thing. And there is no overarching. Okay. All right, you're comfortable with this one. I'm happy with that. Even though you acknowledge you're more active in this one. Okay, fourth one. And I know this resonated in Slovakia, so I'll see what you have to say about this one, whether it fits or not. So in your state, it is against the law to engage in euthanasia, to assist someone in ending their life. Assist someone in ending their life. Is true here? Okay. So you have a client who comes to you and says, I want to end my own life, or I want to help my friend end her life. She wants me to do this. I know, as you've told me before, I am not allowed to do it in Czech Republic. Where can we go to do it? Where is it lawful for me to go and do this? Now, maybe no one in the room knows the answer to that question. Switzerland. Okay, you do know the answer. And you've already told me now. Would you tell your client that? It's allowed in Switzerland.
I think so.
You would say you would say this is allowed in Switzerland. And like the speed, like the driving speed, like the tax one, you are comfortable with the idea that you are just providing information, and if the person chooses to do it, it's their choice. You're not buying them the air ticket, are you? to go, right? You're not going to travel with them and, you know, buy their hotel room where they will do this act? No?
Actually, even in Switzerland, they cannot do it by themselves.
Oh, they need
Some
some,
medical commission.
they need some, okay, they need some approval or
Some
something.
physician.
But you will tell them all that. You will say, here are the rules, here's how you go about doing it in Switzerland. Is everybody comfortable to do that? Everybody's okay. So far, we're good. Okay, I have two more. We'll see if you're still going to be all right as we go forward. Again, here we were talking about kind of laws and their enforcement. You're providing information about laws and their enforcement, and a person who chooses to go, it's their choice. They get to decide that. The client decides that, not the lawyer, you say. I give information, they do what they will with it. And I'm not responsible. All of you have been saying over and over and over again, some of you want it in writing, but over and over you have all been saying, I'm not responsible for what they do with the information I give to them, right? Okay. Fifth one, I think I'm counting right. You have a former client of yours who comes to you. He has been your criminal client, criminal defense client, multiple times. You know, because you were his lawyer, about several horrible things that he's done. You know the truth, even if sometimes you have been able to have him acquitted, or sometimes he has gotten a shorter sentence because of your efforts. Congratulations. You did a good job. And he comes to your office. You don't know at this moment that he's charged with any particular crime, but you know his patterns, and he says to you, Jan, which countries do not have extradition treaties with Czech Republic? You're a criminal defense lawyer. You could get that list in 10 seconds. Will you give it to him?
Well, that's a question. I don't know.
You're not sure if you'll do it or not.
I'm not sure.
So you will send him to these guys. You will say, I'm not sure, but while I think about it, go to these guys who will tell you everything no matter what.
I asked him why he wants to know this information.
You will say, why do you want to know? And okay, I'll be your client. It's none of your business. Just tell me the answer. I'll pay you the fee. I will pay you a fee, you know, a reasonable fee for your knowledge. That's what I'm paying for when I come to see you. I will pay for your knowledge.
I must think about it.
You're going to think about it too. Is everybody thinking about it, or has anybody made up their mind? I will or I will not tell this information. Does anybody make up their mind already? Or is everybody going to send the client out in the hallway and say, I have to think about this for a while before I give you an answer?
For me, it probably depends on his previous record, if these are tax crimes.
Oh, his prior crimes.
Yes, yes.
Oh, his tax crime. If he committed a lot of tax crimes, you will say, there's no harm in those. It's okay. You can flee to Argentina. No worry for me. But if they are violent crimes, let's say, for example.
Maybe he go only to holiday. Maybe he goes.
Maybe he's only going on holiday to a country. He just thinks it would be pleasant to be in a country with no extradition treaty with Czech Republic. For some reason, he thinks they all have good beaches or something like that. So you don't know why he wants to do it. You're getting closer to saying, I'm okay, I'll tell him. And you gave an interesting answer that I think in a few minutes we'll come back to, because you said, well, it depends on the context. I might give him the answer in this circumstance, but not that one. That's what you said, right?
Yes,
Yeah,
I think,
yeah.
Anyway, I would consider this advice legal, but my personal ethics, it would matter.
It would bother you somehow to tell him, depending on who he is and what he's done in the past,
Yes.
and what you're guessing that he's done this time. You don't know for sure, but you think maybe he's done some bad thing, or maybe he hasn't killed anyone yet. He's getting ready. He wants to have his ticket in hand to fly to Buenos Aires. As soon as he finishes killing the next guy, he wants to go directly to the airport. And he wants your help getting ready for it. I'm completely making this up. But it's possible, right? He's preparing to do a crime, and he wants to be, he's a very efficient guy. Right? He's a good planner.
But what if somebody from the street comes and asks the same question? So it's the same.
It's the same.
Dilemma.
Yeah, it is. So would you tell them or no? Would you tell somebody you don't even know? A new client, somebody you've never seen before, you know nothing about his or her background, and they just come in off the street to your law office. It sounds improbable, I get it. But they come in and they say, where are the places that have no extradition treaties with Czech Republic? They're asking you a legal question, right, about the status of law and how the criminal law that exists is enforced or not enforced, you know, in extra jurisdictional ways and things like that, right? They're asking.
I wouldn't feel comfortable.
You wouldn't feel comfortable.
But I can't find any legal reason to refuse.
Tell me why you wouldn't feel comfortable. You were very comfortable telling someone it's safe to go over the posted speed limit. You said you were very comfortable helping this young couple to violate the sex laws in your state. You were very, very comfortable telling somebody about the tax laws, even though we all agreed that empirically there's some increased likelihood that people will violate those laws if you give the information. You were all fine with that, right? Why now?
Because, like the cases before, in my eyes, it wasn't so serious.
Okay, this one is more serious and too serious for you. Okay, is anybody going to give the, you know, or what would you say? Would you say,
I don't know.
you would say, I don't know, but you do. You will make a false statement. Is it true?
I don't know yet.
I know that you have a norm in your law on advocates that requires that advice be candid or something of that nature. Advice be truthful to clients. So you're not supposed to tell them, I don't know when you know. You're supposed to say, I know and I won't tell you.
I don't want to be rude.
Yeah, I understand, right? Yeah. If he studies long enough himself, could he find this information?
Yeah.
Sure.
Yeah, you can write.
It's not easy, right? It's not completely easy. For you, it's very easy. For this person, it's very difficult. That's why he's asking you. But it is public information.
You know, I think a lot of, how can I say it, people who commit crimes in Czech Republic knows law better than somewhere. You know.
Okay. Okay. All right. Fair enough.
There are
Criminals.
some support groups for criminals going abroad.
Ah, support groups. They meet during the evenings and
And they discuss the ways of the law.
have a beer together and talk about how it goes. Okay. All right. How many will tell him? Okay, at least a few. How many will absolutely not tell him? Nobody. Everybody else is still thinking about it. You are, one of my favorite words is you are at equipoise. Equipoise. You are at this point where you cannot possibly tip off one side or the other, right? It's not possible to make a decision. All right, okay. That's good. That's actually exactly where we ought to be now. Now, how about one more last one? You have a former client of yours comes to your office. This client you have represented multiple times in the past. on charges that he committed sexual assaults. And you know, you are his criminal defense lawyer in the past, so you know his secrets. You know them. You know that he was guilty of these sexual assaults. You are aware of it. You represented him nonetheless. That's what criminal defense lawyers do. But now he comes to see you and he says, you are a great criminal defense lawyer. I am so happy that you've been my lawyer for these many years. You do such a great job. I know that you are among the most knowledgeable criminal defense lawyers about how the police function, how they enforce the law. And I remember some time back you were happy to tell me, for example, that the police won't stop me on the interstate, on the high-speed road, if I go 138 miles an hour. 130, no, it would stop you if you go 138 miles an hour. Kilometers. I haven't completely landed yet, I guess. Now what I want to know is what parts of our city do the police not enforce or not patrol very often at night? I want enforcement information from you about the law, like I've asked you for many times before when I had tax problems, when I wanted to buy a house, when I was considering euthanasia in the past, and you have always answered my questions faithfully. I wish some additional enforcement information that you as a lawyer know more than a normal person can know. How many will tell him? I think no one.
I would say I don't know.
You wouldn't. Would anybody tell him? Would anyone tell him? No. I don't think any of you would. And it's been the rare person in all of the times and all of the places. I've done this class with my own students 25 years. You know, I could count on one hand out of thousands of people I've done this class with, how many would say, well, I guess it's his responsibility what he does with the information, not mine. I'm just providing information, right? Maybe 4 or 5 out of many, many thousands. None of you here would do this. Why not? What happened? What changed from one of these fact patterns to the next one, to the next one, to the next one, and finally, in the big way, to this one? Some of you were close to kind of falling off of the idea that I provide information and clients do what they wish with it. It's not my responsibility. On the extradition treaty example, several of you were close to kind of falling off of it there and saying, I won't do that. I won't give that. And mind you, I'm not endorsing one answer or another. I'm trying to explore with you what you think it is that occurs that changes your view in what I think are kind of theoretically analogous situations, right? From the speed limit to the next one and this final one. What is it?
I think that it's a level of danger for society.
It's a level of danger for society, okay?
It is not publicly, it's not public.
Well, it's not public, but couldn't any person, I'm going to challenge on that, it's not public information in the way that some of the others were, but couldn't a diligent person do their own study of this and come to the conclusions? It's open for all to see. If you went to the different parts of the city at the same time every night for 10 nights in a row, you could draw those conclusions. You could do an empirical study of it.
No, but it's basically insider information from the police department.
It is more inside information than some of the other ones. The tax one, you know, I said, you know, tax people get these documents and they know things that other people don't. They could find them if they worked very, very hard to find them, but it's not easy. So I agree that plays a role, but I think it's a smaller role than we might think sometimes. So it's the gravity of the harm, you say. Anybody else?
It's much closer to the crime, I feel, that the speed limit, okay, you can, but why someone asked for the extradition information, why someone asked for the places where police don't patrol, it seems to me it's closer to break the law.
Okay, and you said earlier, on the extradition one, I think it was, that it might matter to you who this person is.
Yes.
What you know about this person, right? Vita is now evaluating, I think he is, tell me if I'm missing it, I think he's evaluating the likelihood that this information will be misused.
Yeah.
I think that's what's happening, right? And I think if we spent all day talking about it, which we won't, we've already spent more than I planned to, I should say, I think we would put those two things together, the likelihood that it will be misused and turned into unlawful conduct, and the gravity of the harm that will come. And I think in our brains we do mathematics. We take those two factors together and we come up with some sort of place in our mind that is sort of the grievousness of this, because it's how likely will it happen and how bad it will be if it does. And we come up with this number somewhere. And when that number is too high, we won't give the information. But they are, I hope you'll agree, they are analogous situations, at least some of these, with one another in terms of, I want to know the enforcement pattern. There is an aspect of how easy or difficult it would be for a person to get this information without you. It's always available at some expenditure of effort, right? So there is something to that. But I think it is mainly that we exercise some sort of contextual judgment about these things. It's not so much that we can distinguish them very easily from each other on a theoretical basis. But we do this we contextualize the circumstance of giving the information and allowing the client to make decisions from it. And that's how we decide ourselves, should we give out the information or not. Now, the legal norms that are out there are pretty general. They're not so helpful when you get down to actual cases, actual instances. They say, for example, in the US, and there's something similar in Czech law, a lawyer is not permitted to assist the client in committing unlawful acts. Okay, right? At the beginning, we were sort of saying, well, I'm only assisting if I get in the car and I push down the pedal. Right? I'm only assisting then. But in this last case, you didn't say anything like, I'm not assisting if I don't take him there and and be his lookout for him. No one said anything like that. We're just giving information. But we think it's so likely to be used, we think it's so grave if the harm comes, that we decide not to give it in the last case, and to give it for sure in the first case, and most of the ones leading up to the last case. And that's not too helpful if we're trying to apply a norm that just says, I'm not allowed to assist. Right? Because we think in our heads that assist means something different when the harm is so great. We think less assistance ought to be prohibited when the harm is so great than when the harm is small. So the word doesn't capture it, at least for me. The word is not enough to capture it. Only thinking about it in the context of multiple examples gets you to the point where you can think about it. Okay, how did the legal theory people like that? Would it also be a good way to introduce students to the idea of what is law? Would it help? No. Why not?
Because they would be confused.
Ah, okay. How would you make them not confused? Make them read Dworkin. And then they will not be confused anymore.
I think that they need to know how to see the borders of the
Mhm.
system.
Okay,
And as a teacher, I should provide them some guidance.
okay.
Because they can be just for themselves.
Sure. Exactly.
Maybe that I can discuss with them the meaning of legal norms
Mhm.
in their relationship to the social acceptance of the norms.
Okay. Mhm.
You discussed
A
earlier.
little bit.
I don't think that in these cases there are straight answers.
Mhm.
You need to think about each case
Mhm.
particularly
Mhm.
and try to imagine yourself in the situation,
Right.
because you can't say that in this type of situation you need to solve it in that way,
Mhm.
because it's so particular.
Mhm.
You cannot offer a general rule
Mhm.
of how to solve it.
Which is to say that it's like life. Right? That's how life works, that it's not easily captured by an article, words in an article. Yeah. Okay, so that was the class. So I would run that class that way, and of course the kind of the takeaway at the end is to kind of look at how we behaved and how we thought all the way through, and talk about this idea of contextual judgment, that there is something to that the theoretical application of the word in the norm is not always enough to be able to distinguish cases from each other. And I think it would be hard theoretically to distinguish these cases from each other, some of them, until you get into the idea of start thinking about how do people actually process the information about the likelihood of harms and things like that. Okay, any questions, comments, things about how that class goes? Did I get most of you involved? Yeah? Okay. Did I make anybody uncomfortable? Darn.
It's been very fine.
Huh?
It's been very fine to discuss. The
Good to discuss it this way.
cases and model cases and
Okay?
things like
Okay.
that.
Okay? Okay.
It's great to just example something that everybody knows.
Yes, yes, exactly. And I like that first one especially because you don't really have to have any law training yet. You could do that with 18-year-olds. You know, that one you can kind of start out with 18-year-olds. And if they will accept your statement about, you know, what the law is on the tax law or the criminal law or things like that, you can very quickly get them to be comfortable talking about all of those, even if they're fairly young people, right? So you're LLB students. What do you call it, LLB, or just bachelor's? Your first degree in law.
You don't have it. You have only a master's for 5 years.
Here you have only masters. So where do they take their bachelor's degree? Sorry.
You don't have a bachelor's.
Lawyers do not have.
There are some bachelor programs, but they are specialized. They can continue to legal professions
You
like
have
judges.
2 levels of legal education. In order to become judge or attorney,
Okay.
you need to study 5 years in life, and then you need to pass.
Oh, okay. So there is no bachelor's degree along the way. You study for 5 years to get the master's, but you start out when you're 18 years old or 19, something like that. Okay. All right. Okay. Got it. I understand. As you know, in many places, you get an LLB along the way, and then you go on 1 or 2 more years for the master's to make it 5 years or something. Okay. All right. Anything else? Any other questions, comments about that exercise?
But short comment from my side.
Uh-huh.
Just for our colleagues, for teaching purposes,
Yeah.
it's not about only attorney, advocate, and client relationships. You can take it also from the point of view of judge. to discuss what would you do if this case will come to your table to decide. Will you punish this lawyer for giving advice or discipline him for providing this information? So it's just model situation, and you can take it from different sides.
Sure.
It's not only about lawyers, private lawyers, and clients.
Sure, absolutely. I mean, anything that a lawyer does that involves litigation can be before a judge. So, I do want to emphasize what I think I said at the forum yesterday. Some of you were there to hear that even though, you know, we can talk about professional ethics, the starting point for talking about ethical norms for a professional is the role that they fill in society and in the justice system. And so yesterday, for example, we talked about conflicts of interest for lawyers, and we talked about impartiality concerns for judges. And both of those, they have one place in common. They are both interferences with the professional judgment. Right? They are both interference with the professional judgment. But it's very important to see that they're not the same thing. They are not at all the same thing. Conflicts of interest for lawyers, impartiality problems for judges, because lawyers are meant to be partial. It's their job to take a side. The interference with their professional judgment is their professional loyalty to their client. It is their partisanship that gets disrupted by the conflict. While a judge starts from the premise that all the professional norms, all of the professional conversations about ethics for judges start from a different place than that for lawyers, in that judges have a different role in the justice system. They are the neutrals, right? So their professional norm discussions, even though we can say both of these things, conflicts for lawyers, impartiality problems for judges, are interferences with professional judgment. Judges, it's the interferences with their neutrality that we care about in terms of their ethics. So on the surface, it may be that you can say conflicts of interest for lawyers, impartiality things for judges are the same in the sense that they are interferences with judgment, but they are not at all the same. They are fundamentally different. They are things that will threaten my partisanship if I'm a lawyer, and things that will threaten my neutrality if I'm a judge. So all professional discussions about professional ethics, including doctors, which came up very briefly yesterday at the forum, including doctors, start from the place of saying, what does it mean to be a good one of these in our society? That's the first moment, right? And as I said again in the forum yesterday, we'll probably never get there in any society, including mine or any place else I've ever visited. But if we were ever able to capture perfectly what it means to be a good lawyer in our society, what it means to be a good judge in our society, in the law on judges, in the law on lawyers, in the conduct codes that are adopted by judges associations or lawyers, the laws, all of the different ones, high-level ones and low, that govern professional behavior, if we were ever able to capture it perfectly, then there would never be a difference between doing the job well, technically well, and doing good. Because good would be serving that role perfectly, right? Now, nobody's gotten there. Nobody has gotten to that spot. As a result, we have, as we did yesterday, we continue to have, and probably will, long after my death, we'll still be talking about the places where professional norms are not leading to good results, make you feel like a bad person when you engage in what the law tells you is the good conduct or the proper conduct, the correct conduct for a lawyer or a judge. Okay, but this role thing I think is really important to see, because yes, A lawyer ethics issue can become a judge's issue if a judge has to decide it, for sure. But judges' norms come from a completely different place. Even though they are also legal professionals, they come from a completely different starting point, and their role of neutral is what animates everything about what it is to be a good judge and what we think of as ethical norms for judges. Being a good partisan is what animates being a good lawyer. You're supposed to take sides. That's what you do. If our society won't function without lawyers who take sides, then taking sides is good. Right? We are performing this critical role in the justice system by taking sides and being devoted and loyal to our client. So what we just did actually is a good thing, a good example of this. We have to draw a line somewhere on devotion to client. Of course, a good lawyer doesn't devote to client to the extent of hiring large people with sticks to go and beat the other side, right? So we get that, right? There is a limit on the devotion to client. And the norms everywhere that I know place that limit at law. They essentially say, in one way or another, the American norm says it a particular way, others say it in a slightly different way, but they say lawyers are meant to be loyal to their client to the limits of the law. You are supposed to advance your client's interests except when they violate law, right? So we state it in slightly different ways all the time. But those are the limitations. But partisanship is what it is to be a lawyer. And being a good partisan within those constraints is what animates all of the professional ethical conversations. I don't know if that helps at all or not. No, it doesn't. Okay. Because I know there's been some interest in having kind of a unified conversation about professional ethical norms. That is about judges and lawyers and prosecutors and everybody all at once. But in a way, that's not possible because their roles are different. You start from different places to figure out what it is that lawyers should do, judges should do, prosecutors should do. So anyway, yeah.
Is there do you think is there some common ground or not?
The common ground is so general as to be almost meaningless. The common ground is that each of those professionals should fulfill their role in an excellent way, right? So I think that's the common ground. But as soon as you say that, now you have the word role in here, and you start to ask yourself, what makes the good partisan? What makes the good neutral, which is what a judge does, right? I mean, if you ask criminal, and I know criminal defense lawyers maybe have even stronger feelings about this than lawyers in civil matters and corporate matters or, civil disputes of one kind or another. But if you ask a criminal defense lawyer, and I mean a good one, and I don't mean a talented one, I just mean one who is playing their role excellently, if you ask them, is their job the pursuit of justice? They will say no. They will say no, and I think they're right. Their job is the pursuit of their client's interests within the bounds of the law. They are not entitled to pursue their client's interests by violating law, which is what we were just talking about in all these examples in one way or another. But they are supposed to want the interests of their client. And a good criminal defense lawyer whose client is guilty does not try to help him be punished properly. That's justice. But that lawyer's job is not to help their client get punished. And we need to accept that if go ahead.
What if I, as a lawyer or as an advocate, have my own internal limits, ethic limits,
Mm-hmm.
when I'm not devoted to my client, because I just ethically don't agree with the case, his behavior, and so, and I refuse to advocate him.
That's the proper thing to do, to refuse to advocate for him,
Okay, and
rather than agree to advocate for him and do it wrong.
yes, but the problem is that as an advocate, you don't have to you don't have to like legal means to get enough information, for example, at the beginning. So you just get the case, you begin to represent the client, and after then you realize that there is some ethic problem. And does it mean that if you end the cooperation, you are bad lawyer?
No, it doesn't mean that you're a bad lawyer. It means that you've decided that you cannot do the job of a good lawyer for this client. And the better thing for you to do at that stage is to withdraw from that relationship and let someone else who can be the good lawyer for that client do that job. That's the better thing to do. And there are definitely people who should not, I mean, I've had many students that, you know, I've had to say at some point, please don't do criminal defense work. Right, it just doesn't suit you. You will not be able to do it and live with yourself. And I want you to be, all my students all over the world, I say, I want you to be able to live with yourself, right? I don't want you to have the kind of life that you are doing things to do the role properly that are so distasteful to you that you sort of can't sleep nights, you can't have good functioning relationships with your loved ones. No one wants that. But there are people among us, maybe in this room, maybe not, who very much have the capacity to see that even if it offends their personal norms, if they fulfill this role effectively, that the society needs someone to do, then they are doing good. Right? There are people who see their way to that end. They're the ones who should do that kind of work. I don't know if that helps or not.
Well, it could be a decision, because I'm a practicing lawyer, and criminal cases I take usually in 95% only from court. So when I'm
appointed to.
I see, okay. So because then I don't have so much problem to decide about I like or I don't like. It's the role in society. I think, okay, there should be someone who will take these cases. I can do it, I think, in a proper and good way. And for me, the discussion is interesting because I want to do it in proper and good way, but not cross the limits. So what is the limit of effective and legal defense of criminal clients? Yeah. But usually I don't take criminal clients from the street, because I don't want to solve is it good or bad, is it true or not, and this. You don't want to have to make that initial decision. You just want to do the job as well as you can within the right limits. Yeah. So that's an important role. That's an important thing that people need to do, and that's a very honorable thing that you do. I'm sure you wake up and feel good about your life. And it's just no, I'm serious. I'm not. It's just explanation for colleagues who don't have this experience, because I tried to. Of course, for district attorney, the criminal cases are good. It's not best from the financial side, but it's some money comes from the court. So of course you have to also decide, at least in the beginning of your career, if you want to not accept this money. So that's hard decision. But I'm not in this situation now. So my decision was, okay, I can do it in a good way when it comes from court. The limits on advocacy are something I was actually going to just talk very briefly about today anyway, so this is a good time to do it, right, because you've raised it excellently. Because those are part of every good course on professional ethics. The limits on advocacy are part of every good course. We just spent an hour talking about those limits in a certain way.
right? That was what we were doing in part. We were talking about the limitation of not helping your client violate law. That certainly is a limitation. You may not help your client violate law, and again, we need the theory people to tell us what law is. But nonetheless, that's the most kind of widespread normal limit that's accepted in every country where I've been. So that's a very normal limit. It's interesting, though, that the other limits in the law come in the form of what are described as duties to other people than the client. So let me give you examples. Every law on lawyers I've seen, every code of conduct that I've seen, says something about the level of truthfulness that lawyers must have, right? And they say slightly different things about how truthful and in what context lawyers need to be. So one context is I'm advocating for my client, even if it's in a negotiation. I may not be in court, I may be in court, doesn't matter. But how truthful do I need to be with the other side, right? It would help my client if I lie to you. So if I had no limit on helping my client, on advocating for my client, and I were willing to do it personally, I would lie to you. I would make stories up, right? They would help my client. But all of the legal norms that we have that govern lawyers, the laws on lawyers, etc., tell us in one way or another that lawyers need to be truthful. Then the question becomes, how truthful do they need to be? But we are told we need to be truthful to judges. We are told we need to be truthful to what I will call third parties, people like witnesses, people like opponents, people like other interested parties in the dispute that my client's involved in, even if they're not a party, formal party to the litigation. So we have this sort of list of duties to third parties, included in which is some level of truthfulness. We have this list of duties to courts, included in which is, some level of truthfulness. There are other duties too, but let's stick with truthfulness for now, just because that's a good one to capture. But all sets of laws on advocates that I've ever seen tell us things about duties to others that operate, in my way of thinking of them, sort of like fences around how far I can go to help my client. So I know I can't help my client by myself breaking the law. I know I can't help my client by assisting him or her in breaking the law. And I know I can't help my client if I violate one of these other norms that says I have this duty, this duty, this duty to third parties, to judges, to others. Right? So those things operate as the limits on how much I can do. Yes?
Can I make a question?
Please, please.
If you can imagine some situation that there is a case which nobody, advocate can lead or defend, and because of ethics, and
no one can do it because
no one.
I don't know.
What next?
Case.
Because
Okay.
the person who committed the crime has a right to criminal defense by advocate.
Mm-hmm.
What next?
So I'm
Some
confident.
collision between ethics and law. You know what I mean?
Yeah, I do. Though, so I should free myself of the reality that I know there will be some lawyer who does not have an ethical problem with doing it, right? Because I know that for sure. What would be the case? I mean, are you talking about someone so evil? Someone who,
maybe.
Are we talking about Slobodan Milosevic?
Yeah,
are we talking about...
Breivik, yeah.
Yeah,
If
okay.
you imagine the situation that there is nobody who wants to defend because of ethics,
Someone will. I'm confident that someone will. I believe that always someone will.
My understanding is, I would definitely not take bribing as a client from the beginning, but if you will come and convince me that no one wants to do it,
You will do it.
I will do it because of the principle.
Yeah, so someone will do it. Now, I do want to, because we're trying to bridge things between judges and lawyers, and I'm sensitive to that. And actually, our last topic today is going to be about speech rights of judges and lawyers. We're going to see how they're different in some ways, okay? There is a principle of judging that says if every judge would be disqualified, then any judge may go ahead, right? And here's the example of the case, and it's a real case that happened in the States, so I know it can happen because it did happen. There was a big dispute, a legal dispute, about the retirement benefits for judges. And it came to court. All of the judges in the state had their retirement benefits at question in this dispute. They all had, every single one had a financial interest in the outcome. And normally, we would say, as we did yesterday when we talked about impartiality, normally we would say a judge who has a significant financial interest in the outcome of a case is disqualified, cannot be impartial, right? But our Supreme Court said, well, everybody's entitled to the legal forum. Every person, even if all judges would be disqualified, is entitled to bring a case in our courts. We cannot countenance the idea that if it is the kind of case that disqualifies all judges, you can't bring it to court. So, the Supreme Court said, that means that all judges will be permitted, even though they have this financial interest in the outcome, because there is no choice. So, it's like your example, right, where everybody has an ethical problem with something, but somebody has to do it, but it's for judges instead of...
But it's question that if advocate who must defend this client, because it's official, for example, if he do it in the best way, he can. If he has not the ethic, how can I say?
If he's a good lawyer, he will do it in the best way he can within the norm.
For ethics, but he must do it.
That's what makes him a good lawyer. Have you ever read the book? It's an American book, but it's a great lawyer book called To Kill a Mockingbird. Has anybody ever heard of that story? Maybe you saw the movie or read the book.
Of course.
Okay, everybody says of course? No, of course not. Okay, so some of you say of course, and others are saying, no, what are you talking about? So, it's called To Kill a Mockingbird. It is the most profound story of a personal lawyer's conflict of interest that I can even imagine. I'll tell you the story briefly. I don't want to take our whole morning with it, but it's a lawyer in a southern American town in a place that is very, very prejudiced, very bigoted against black people. It's a place where, slaves used to be held, no more, of course, but nonetheless, it is still that kind of place in its spirit. There's a black man who's accused of committing a sexual assault on a white woman. And in this particular cultural setting, there could be no greater crime, right? In the mind of the people who are there and live there, this is the most heinous thing that they can possibly imagine, all right? Somebody has to defend him. And there were only a couple of lawyers in town. And there's a great scene in the book, in the movie. The lawyer is sitting outside on his front porch. And it's a summer evening. And he knows about this crime that has happened. It's everyone in the town knows about this charge that has happened. And he sees the judge walking toward his house. And the judge asks if he could come up on the porch. And for me, right, being a lawyer, teaching about this for so many years, I imagine what is in that lawyer's mind as the judge walks up on his porch. He knows the judge is going to ask me to defend this man. He knows it. And he already can hear his children who are inside the house. He has 2 young children. His wife is deceased, so he's a widow. He has 2 young children. He knows where he lives. He knows the small-mindedness of the town where he lives. He knows the hardships and even danger that will come to his children if he agrees to represent this man. He understands this even as the judge starts up the steps, I'm convinced. And nonetheless, as soon as the judge asks, he says, I will do it. And he does. And the question is, will he do it well? Or will he do it in a way that pleases all of his neighbors and not really defend the man, but just do it for show? You know, do it for the show of having the processes done? Or will he actually try to defend him? And of course, in the story, he comes to realize that the man is not guilty. He didn't do what happened, what was charged. And he vigorously defends him, even while his children are being threatened and hit, and even while the father of the girl who was assaulted, who is coming after his children in drunken stupor with knives, he keeps doing this. And to me, that is the most profound personal conflict of interest that a lawyer could have. If I do my job well as a lawyer, I put my children in danger. Can you imagine anything, you know, more grave, more serious than that? It's not money, it's your children's well-being. And the question is, do you do your job well and have it happen that way? And of course, in the story, he does his job well. So it is often used as the example of the great lawyer. This character, his name is Atticus Finch in the book, he is often held up as the example of the lawyer who does good. He is doing his role in the perfect way, even at great risk to himself and his family. So, I don't know if that helps go into your question or not, but it's a great story. It's a great story. And the movie is fantastic. The movie is great too.
And how is it called?
To Kill a Mockingbird.
Oh, thanks.
And you'll hear the line in the movie if you watch it sometime or when you read the book. Okay, sorry. Limits. Limits on helping your client. Right? We just talked about some of those limits. And I want to try to, this will take 5 minutes. Let's put the lawyer in the setting of a negotiation. So the lawyer is negotiating on behalf of his client for the purchase of some land or the purchase, does this happen? Would the lawyers help negotiate things like this? Purchase of land, business transactions? Sure. Have any of you ever bought anything of consequence? Have any of you ever bought a car?
No.
How truthful were you with the person you wanted to buy the car from?
I think I was lucky.
Lucky, okay. Your example is being lucky, okay.
Because I knew the owner of the car, and it was a neighbor of ours.
All right, okay. So you had confidence in each other.
Yeah, I had confidence.
Let's just make it hypothetical then, so that we can get to it. If you go to buy a car, and you see this car, it is a red convertible car with a great engine and will go very fast, and you are the kind of person who needs to have a red convertible car with a big engine to go very, very fast. 130? Forget it. You go and you see this car and you need this car. That is truth. That is truth inside you. Will you walk to the person who is interested in selling the car and say, I have to have this car. I am desperate to have this car. Will you tell them the truth? No. Everybody says no. What will you do instead? What will you do instead? You will ask about the price. You will say, how are these tires?
The conditions of the car.
Yes, how many miles, kilometers have been on this car already? The seats seem not so good. You will try to mislead them. You might not say a lie. We might find a place where we could say, you might not say a lie, though some of you in the room would. Some of you in the room would actually say out loud, affirmatively, it's an okay car. You don't mean that. That's not true. It's false. It's absolutely false. But you might say it. And I bet everyone in the room, even if you would stop yourself from saying something affirmatively false, would hope by your conduct to mislead. You want the seller to believe you are not that interested. Because you know what will happen if you show too much desire. You will pay more. You will pay more. It's the same thing when you are negotiating a business contract, when you are negotiating the sale of a piece of land. Right? So, do we expect lawyers on behalf of their clients to walk into the negotiation and say, the most my client will ever be willing to pay is 1 million euros? And the person on the other side says, great, 1 million it is. Do we expect them to say that much truth? It's unrealistic to expect that. It's unrealistic. So if anybody ever said to you, the norm is that the lawyer must always tell the truth, they're not really thinking about life. It's not possible for that to be the norm, even if it says those words. I'm not talking about trying to be dishonest. I'm talking about human nature and human interactions and how we behave in ways that are very socially acceptable. I'm not talking about things that are unacceptable. And I'm not talking about going into a court and telling a judge something that's false. I'm not. Because that must be prohibited. We can't have lawyers who walk into court to say, my client was in Pezinok at the time of the crime that took place in Pilsen, when we know that is false. We do not accept lawyers to do that. We should not accept lawyers to do that. So there are limits on, what word do you want to use? Misleading, deception. Lawyers do engage, and so do everyone else, in some levels of misleading conduct that are socially acceptable, normal, and I think cannot actually be avoided. I think if we prohibited them, we would sort of all laugh. If we think about it. We might prohibit them and say, wow, we have a great standard here. It's perfect, right? It matches our aspirations and our virtues, and it's totally unrealistic. So we need to think, and the law tries to do this, right? Imperfectly, but the laws on lawyers try, and the way judges actually make decisions, the way disciplinary boards actually treat lawyers in terms of disciplining them and so forth, try to fashion a high standard that is still realistic. So we expect more truth from lawyers in court. And yet, even in court, we know that in most settings, Etha's a criminal defense lawyer, he can tell me if I'm right or wrong in Czech Republic. Criminal defense lawyers are not obliged, for example, to go into court and tell all the bad things about their client. That's truth, right? If I know all sorts of secret bad things about my client, and I'm told I must be completely truthful, they don't match. Because I'm not going to go into court, and no criminal defense lawyer is or should go into court to say, I've had conversations with my client, here's why he's a bad person. That's truth. If all you want is truth, that's what you'll get. So there are limits on advocacy, but we need to be sure they are realistic limits on advocacy and not set standards that don't allow a system to function. We expect criminal defense lawyers to not make affirmative false statements. In the standard in the US, they say it's a material false statement. So I'm not allowed, as I said a moment ago, I'm not allowed to stand up in court as a lawyer when I know my client was in Pilsen where the crime happened and tell the court, I can absolutely assure you, Judge, my client was in Pezinok.
Yeah, but there's a difference because the client can say, I was in Pezinok, and I can't say, I know he was in Pilsen.
You can't.
So I
Exactly.
will say, okay, my client says he was in a Pezinok. It's okay.
Mm-hmm. But you maybe stay silent and not correct what you already know to be false about what your client said.
Because I don't make a statement that it's not my evidence. I'm not a witness of this. I don't say to the court, I was with him.
Of course
I say,
not.
My client, version of my client is that he was there.
Yes.
It's up to the court.
And then you leave it alone
Yeah.
from that point on. Right, okay. Anyway, there are limits on advocacy. One of them, but not the only one, involves truthfulness. Others involve acts that are actually violating other legal norms, criminal acts. And another is the assistance of clients in committing criminal acts, right? We have these limits set up on advocacy, but I caution you that the limit relating to truthfulness is not a simple one. It is not a straightforward one. And there are shades, right, going from black to white that we go through, from lying to dissembling and misleading conduct, even to the point of keeping our face still when we are excited inside. We call it, do people play poker? Yeah, so we call it a poker face, right? A poker face is one that doesn't tell the other side what your cards look like. And that is an act of deception. It is intended to cause them to think something other than truth. But could we outlaw that? Could we say that an advocate cannot maintain a still and stern facial expression when they know something terrible about their client? How could we do that? Okay. So the crafting of these limits is something that takes a culture, a legal culture, quite a long time to come to agreements about. And even then, they are not completely certain. They are not completely certain limitations that we will never have future disputes about whether they've been violated or not. So I actually wanted to talk about that just enough to make clear to anybody who will get interested in crafting a professional ethics course that we've talked yesterday and today about some of the topics, some of the core topics, but one of the other core topics involves these duties to others that form boundaries around our advocacy for clients. So we think of the lawyer as first owing a duty to the client, which is limited by duties to third parties, duties to judges, duties to other lawyers, colleagues, and the like. And those other duties sort of form the boundaries beyond which lawyers may not go on behalf of their clients. And that's a big part of every professional ethics course that I've seen. Other parts that I'm not going to actually spend any time talking about, but it's normal to talk in a professional ethics course, professional responsibility, however you want to frame it, or professional conduct course, about things like how does the lawyer-client relationship begin And how does it end? What are the ways that it can happen? Talk about things like the setting of fees, proper fees. And in some countries there are fee tariffs that set certain limitations on how much the fees can be, how high they can be, how low they can be, things like that. In other societies there are no such tariffs, and the standards are very vague. You know, lawyers, to be ethical, must charge reasonable fees. But what is reasonable if you are a lawyer of 30 years experience with great expertise in a particular subject matter that is very, very valuable to a very big business is, you know, not the same as what is reasonable for a beginning lawyer to charge on a routine matter, right? So there's a big space that accounts for expertise, for difficulty of the matter, and all kinds of things like that. So fees is often talked about. We're going to talk briefly before we finish today about advertising and other forms of client getting, because we're going to talk about speech, what lawyers are allowed to say and not say publicly. But that forms part of most professional responsibility courses. What are the rules here, by the way? What are lawyers allowed to do in the way of advertising their services to the public? Does anybody know?
Yeah, we could advertise.
You're allowed to advertise.
Generally, we don't. We are not allowed to approach potential client to offer
face-to-face
services or send a letter to the new company which I never had a contact before, or ask someone else to make an acquisition for me to spread the leaflets or something. So when I meet someone personally, we can talk about things, and I can mention that I'm a lawyer, of course.
Yeah.
Before, I don't know, 5 years before, it was prohibited to make advertisement.
Right, that's what I thought. It had changed here not too long.
It's more open. Of course, it could be truthful and
it has to be truthful.
Not comparative, of course, and this, but it's probably more strict than in general competition law.
Yes.
But it's possible.
Okay. Generally speaking, societies are becoming more permissive with lawyer advertising than they had been previously. It's, you know, in the U.S. it changed dramatically in the 1970s and 80s, before which it was almost entirely prohibited for about 70 years. And now it's very, very open. I could show you a couple of American lawyer ads that would probably make your heads spin. But, and if we have time at the end, I will do it. Yeah, I'll do it. But one thing obviously that's happened in countries that prohibit lawyers from advertising, still, it's impossible now. All law firms, or at least big ones, have websites. Those are advertisements. They are nothing but advertisements. They are about trying to get new clients. And, you know, nobody is, I haven't seen anybody, any country, telling its lawyers, you may not have a website. I've not seen that happen, right? Or you may not have a Facebook page even, or something like that, right? So anyway, so advertising would be a part, and it would take account of technology when you teach about it, for sure. And then there would be, if you were teaching a professional ethics course, there would be a whole block of material on judicial ethics. And it would start, as I said a few minutes ago, from the premise that the judge is the neutral. The judge is the public decision maker, something lawyers are not and are never meant to be. Judges have a different role, and as a result, they have much more constraint on them in terms of public appearances, public statement, things like that, than lawyers do. They have many more constraints on them in terms of receiving gifts. Clients can give lawyers gifts anytime they want, pretty much, right? Would it be a problem? No, of course not.
Do it.
They don't do it enough. But I understand they don't do it enough, but it's not an ethical problem. But with judges, of course, it is an ethical problem for them to receive gifts from, you know, participants in their court. We talked about it a little bit in the impartiality bit that I did yesterday. So we start from a different place with lawyers and judges, but we would certainly have you know, a block of several class sessions in which we would talk about the ethical norms for judges and the constraints on judges and so forth that proceed from their role as the neutral. All right, I think we should take a break. We've gone almost 2 hours now, so let's take 15 or 20 minutes, come back about 11:15. Okay? Shall we start? So one of your colleagues reminded me of something that I should point out. It's a great point. A movie that you might see, a modern one, that has something in common with the movie I described, To Kill a Mockingbird, the story I described, is called Spy Bridge. Have some of you seen it? Spy Bridge? Isn't that the name? Yeah. So it's a really interesting movie. It's a fact-based movie. I'm not going to tell you the whole story, promise. You should watch it. I think it's really good. It is about an American lawyer in the 1950s. Yeah, it's in the 1950s. American lawyer who is asked to represent an accused Soviet spy. And he, a little bit reluctantly, agrees to represent the Soviet spy. And the Soviet spy is, you know, totally hated by everybody. And so much so that it creates problems for his family, very much like the ones that I was describing in the other story. But as she pointed out, and I think she's completely correct, it might be more accessible, more you know, meaningful, the context of the story than Southern prejudice against blacks, which you don't have that much experience with here. So anyway, yeah, you have different things. I understand, and you know, today it's refugees. So we'll see how that plays out over time. But nonetheless, it's a great movie. I was telling her that I only watch movies on airplanes today, these days, but I saw that one on an airplane a few weeks ago, and it was actually quite good. And I remarked to my wife when I was watching it, this is like To Kill a Mockingbird. So it was a good catch that you suggested that, so thanks. All right, I would like to spend a little bit of time talking about the speech, kind of freedom of speech of lawyers and judges. And I think we will see in this topic some of the places where the role of judge, the role of lawyer is different and produces different answers to the same question about a lawyer and a judge. What if a lawyer says this publicly? What if a judge says this publicly? That we might think of their permission to do that or prohibition on their doing that in a different way for them. So I want to focus mainly on three, there are many contexts that we could do, but three particular contexts that produce controversy in many countries where I've worked, including my own. First one we'll talk about in a couple of minutes will be criticism of other legal professionals. So what should happen when a lawyer criticizes a judge, even harshly, very harshly, or a judge criticizes a lawyer, even harshly? Should we put limits on what they may say of that kind? Second, I would mention, would be public statements either about a particular case by a lawyer or a judge, or public statements about issues of public interest, right? About interests that capture the public's interest. And I'll give a couple examples of that and see what you think about whether lawyers or judges or both ought to be restricted in the way that they do that. And the third topic, which initially at least you'll say is only applies to lawyers, and in most of the world it only applies to lawyers, true, and it will be advertising, okay? I'll tell you in a few minutes that it applies to judges in some American states where they are elected. They are elected by popular vote. And there are good things about that and terrible things about that. I'm sure you would be very quick to realize. But some of them, you know, in the process of running for public office, create advertisements for themselves, trying to get people to vote for them. So there are even those kind of things. So I want to talk about all three of those. But I have to tell you that just in the few minutes that we had, I'm sitting here, I get email notices kind of all day long about what at least somebody thinks at an ABA journal place or some other sources of news about lawyers think are interesting lawyer ethics and judicial ethics cases. So you can get on these lists and you get these kind of notices about cases that have been decided all the time. You probably do for your subjects. I'm sure you have similar things. But just while we were taking a break, one such case came through my email, and I read a little bit about it that involved lawyer speech, which is exactly what we were about to talk about. And I thought, wow, it'd be interesting for you to know about this, or maybe not. It's a lawyer who was in a settlement negotiation with another lawyer, and when one lawyer proposed an amount of money that his client would be willing to pay to settle their dispute, the lawyer responding to that offer sent him an email, and it said, I'm going to quote, okay, so don't get mad at me, this is bad language. It said, quote, "You guys can go F yourselves." That's what he wrote back. And the question came up, should that lawyer be punished for making that statement in the negotiation, that statement of a very harsh and rude thing? What do you think? Do you think he was punished or not punished? Not punished. Not punished. Anybody else? Punished, not punished. Two not punished, and no one else will vote yet.
Well, the context is important.
And I just gave it. He was in a negotiation, and
only we know about.
Yeah, that's as much as we know. It was probably a pretty contentious, heated negotiation. They are going back and forth, and they are disagreeing with each other, I'm sure. Right? It's not the friendliest time that you spend with somebody sometimes when, they're saying your client should pay mine $1 million, and you say you're out of your mind. My client didn't do anything wrong. Why don't you? Okay, it's that. Okay. So punished or not punished? Punished. He was not punished. The judge said this is unfortunate conduct for a lawyer to engage in. We don't encourage it, of course. I mean, he didn't say that. But he basically said this is kind of discouraged and you shouldn't do it. But this is not the sort of thing that we would regard as a disciplinable kind of misconduct. So that's what you got. So with my students, what do you think I say about topics like that? I mean, I'm sort of with students now, but you're not really my students. You are already legal professionals, all of you.
I think the topics are very good because they are connected with the real practice life, practical life of a lawyer.
Yeah, so I might give them advice that this is not a way to behave. This is not a good way to behave. It will not lead you to a satisfied life, But I have to also be honest with them, right? I'm their teacher. I have to be honest with them and say, I know of this case and 10 other ones where somebody said something like that and they were not punished. I mean, I can't pretend that they, to discourage them from doing it, I can't pretend that the law says they're not allowed. So it's actually a delicate thing to do as a teacher sometimes. When you're talking about lawyer conduct, sometimes you're trying to encourage them to behave in a certain way that you think is a better way, but you have to also be honest about what the law prohibits and doesn't prohibit. All right, so now let's talk about criticizing each other. So here's a lawyer statement about a judge, and the lawyer says something like, Judge Novak, isn't that the name from yesterday? Judge Novak is stupid, and I believe he may be having a mental breakdown. all of his rulings in my recent case with him have no basis whatsoever in the evidence that was offered or the law. That's the statement. What do you think? How should we treat that? Should that be something that we would prohibit a lawyer from saying? Leave it alone? Or have a parade in honor of the lawyer for criticizing the judge? Which should we do?
May I ask, is it a private statement?
Ah, very good question. Okay. I was hoping someone would say, well, tell me the context. I'll give you many. He might make this statement to a colleague in private, back in their office. He might make this statement to the judge's assistant at the court. He might make this statement to a reporter who will publish it in the newspaper. He might make this statement to the Judicial Disciplinary Board. How would you treat those 4 different contexts? Very, very important question. I'm glad you asked. That was exactly where the next place to go would be. How about the 4 different contexts? Would you punish it in some and not others?
I think that he shouldn't be punished in...
For any of them?
Yes.
Okay. Go ahead.
For me, the important thing is that if it was true that not a stupid thing, but the quality of judgments, there are legal ways to solve this kind of problem. So
okay.
I think if he stated this publicly to the reporter, for example, but even I just forgot the third option.
Yeah, so it was colleague, judge's administrative personnel, right, or clerk or something, media, and disciplinary board.
Yeah. So for me, in the like three cases, he could be penalized.
Could be penalized.
The first one, it's just private conversation.
No punishment for that. Shouldn't be any punishment for that. But any of the other 3 that are public in some sense.
The context still could like could affect the final decision, but
okay.
There could be some proceedings about it.
Okay. So there are ways of determining whether he's correct or not about the judge, at least not in the opinion part of this. Whether he's stupid or not is probably a matter of opinion that people would disagree about, right? But you think there would be ways of determining the truth of the statement that his rulings have no basis in fact?
Well, I think if there was like the form is bad anyway. He should.
You don't like it?
Stupid.
Okay.
There is no point in saying that. But if there was some merit in the rulings that they were really nonsense, then he should use legal instruments to overturn them.
To appeal it or something.
So that's for me the reason he shouldn't like stay this to the reporter.
Okay. Okay. Others? What do you think?
He probably used that, but he will have to.
He may also be appealing at the time he makes this statement. Okay. Yeah, that could be true.
I could imagine that it could be written without idiot in this disciplinary complaint, let's say. So it means to explain detail the cases in which the decision of this judge was bad, according to my opinion, and it could be some conclusion of this.
To the disciplinary board.
Yeah. So as a part of this complaint to the body of judicial discipline, I could imagine it's okay. The idiot is not good, but maybe it's as the result of as the opinion based on these facts, I would not recommend, but tolerate it.
Okay. So not so good for him to say stupid or idiot, but how about the part where he says, I think the judge is having a mental breakdown?
Okay. I could think.
It's okay.
If his decision making is so bad, he should be able.
I think that this depends on culture or in state, because there are a lot of states which have huge protection of freedom of speech.
Yes.
Maybe USA, it's a typical example.
Big protection.
And there is
not complete. It's not 100%, but it's big
I
protection.
understand. But there are another, how can I say it, the level of protection of this freedom, and it depends on.
Yeah, I agree with that. So notice that because of the four contexts that we've given, is there one of these four contexts in which we would actually praise the lawyer's statement? Praise it. Maybe not the word stupid. In the disciplinary thing, right? So we want judges who are doing a bad job to come to the attention of some disciplinary panel, don't we? That's justice. We want justice to improve by having bad judges be reported. And in some systems, but not all, there is an affirmative obligation on the part of lawyers to report the misconduct of fellow lawyers or report the misconduct of judges. And likewise, an affirmative obligation in some systems for judges to report the misconduct of lawyers to their bar association, disciplinary authority, or whatever exists in that particular country. So there's some sense in which we might actually want to praise the statement in the context of reporting it to the disciplinary board, because who else knows better than the lawyers when the judges are doing a bad job, or vice versa? Who else knows better than the judges when the lawyers are misbehaving? So we need them actually to do this kind of reporting if our system is to stay healthy and, you know, become free of the ones who are not doing the job right, of both lawyers and judges, right? So even some harsh language like that might be praised in some setting. You want him to be punished in none, but okay, I see that. How about the media? Let's talk about the interaction of lawyers and judges with the media. So first we had a lawyer's statement criticizing a judge. We could just as easily have a judge's statement that says, lawyer Novak has been in my court many times. He is stupid. He has no business being in my court. He knows nothing about the law. He is completely inept and is harming all of his clients and making justice harder for me to deliver. How about that?
Probably the lawyer will sue the judge for
Okay. Okay. Should the judge sue the lawyer for slander in the same example?
I think yes.
You think will? Okay. Okay.
I think a judge shouldn't say anything like that to the media.
Why not? Why? Do you think judges are different from lawyers, or both shouldn't say it?
Because to be a judge is connected with a kind of dignity of this public function, and these kinds of statements which are not connected to the facts of a case, an instant case, are not expected from the public, I think.
Okay, and we're going to chase that down. We're going to pursue that in a couple of minutes. This idea that judges, I'm not sure you said it this way, but judges should only make public statements about their decisions.
Yeah.
Okay, and that's what I heard you say. That's pretty close, right? Is it accurate to what I have I said accurate?
Yeah.
Okay, good. Okay, good. We're going to go there in just a minute. Anybody else? Lawyers, judges making critical statements about other legal professionals to the media.
Both of these are too general, probably, to say everything was done wrong for a long time. It's not possible. I think we can criticize each other,
okay,
but on specific problem and to describe it more. And the danger is that you can describe it to media, but then there will be just one sentence that we...
Yeah, they won't give the whole description because there's not enough space on the page.
So idiot with facts could work.
Yeah.
But if the result is only idiot, then it's my problem because I should be more careful in my public speeches, both sides.
Okay.
And I feel a little bit for attorneys to criticize judges, the limits are more narrow, let's say, because we want to have a respect for judges,
yes.
even they don't work very well, and we have to use other means than media to criticize them.
Okay.
So I will not prohibit to criticize, but the limits for lawyers could be stricter.
Okay. Let's think about lawyers and judges here. It was said a moment ago that judges should really only make public statements about their cases, decisions, and not about the lawyers, not about the other legal professionals. It's not something that the public wants to hear, needs to hear, will respect the judge for, things like that. But lawyers might think, at least in some instances, maybe not this particular statement, lawyers might think in some instances that their statements to the media will do what? Which is part of their job. Serve their client. Yeah. There are times when the lawyer is speaking to the media and maybe even speaking badly about the judge, right? He may speak badly about the judge in an effort to try to gain some advantage. Now, we could agree or disagree, depending on the context, with the lawyer about whether it really will bring advantage. So if you call the judge stupid publicly, will it help your client in that judge's court? Probably not. But there are times when criticizing the judge in public even could help your client if you do it in a fairly respectful way. At least it might help. Should lawyers have permission to help their clients in this way? Through the media. And I think in many societies they do that with some frequency. But we think of them here again. They are not like judges. They're different from judges. Judges have justice as their first goal. Judges have being impartial and, you said dignified, I think respected by the public in a way that gives confidence in the justice system as a very high goal. Lawyers, less. I mean, lawyers should have some measure of desire to be respected by the public because it does help raise the confidence in the justice system, but not as much as with judges being respected. And lawyers clearly have this other motive, which is to help their clients, and it's a legitimate motive within certain constraints. We keep talking about within the limits. So maybe we should be freer with lawyers who make these kind of public statements. I don't know. What do you think?
I don't agree with that judges could or should only comment on their own decisions.
Okay.
I think they are allowed, and I want they sometimes comments on more general topics.
Okay. Okay.
But it's other issue.
Yeah, let's go there in a minute.
But I agree what you said. So it doesn't make big sense to limit us, the lawyers, more than judges in this context. So I don't know what would function if judge will criticize this the lawyer personally
in media.
In media, what the interest of society it serves.
Yeah, exactly.
Because he probably could more effectively influence the behavior of the lawyer by other means.
Okay, great. So now we're still going to be talking about judges in the way that you just described, but I want to move over and talk about public statements about a particular case. So now the lawyer is working on a particular case in a particular court with a particular judge. And what about public statements by either one of them about that case? How do we react to a lawyer who gets up and stands in front of the television camera and says, my client is innocent, or my client's company has been cheated, and we are here to, you know, fight for their justice. How do we feel about that statement?
It's part of his job.
Part of his job, you say. Okay, so you're comfortable with that kind of statement. Okay. Is there ever a point at which you think there should be a limit on that statement by a lawyer?
Well, certainly it should be in the best interest of his client.
Okay, so we might disagree, we might criticize a lawyer who hurts his client with such a statement, and sometimes it could, so we might disagree with that lawyer. That, I think you'll agree with me, though, will be hard to determine with certainty. We will have opinions about whether this statement helps or hurts this particular lawyer's client. It will be hard to come to kind of a certain resolution, and there will be some that disagree back and forth about it. So it will be a difficult limitation if we created it to enforce.
But for example, about permission of client, if he wants to publish.
We would certainly want the client to agree that the lawyer do this. We wouldn't want the lawyer to reveal publicly information about his client that his client doesn't want to be revealed. So connected to confidentiality duty, a lawyer would certainly have to have the permission of the client to engage in such public statements on his behalf. That's an excellent point. But assuming he has it, you know, going forward this way, how about the lawyer who says publicly, I'm going to connect these two now, okay? How about the lawyer who says publicly, I'm not speaking for myself, understand, but my client says that the other side's lawyer in this case is dishonest and has been trying to bribe the court. So you're laughing? This is exactly the statement out of a, not out of a public statement, but out of a pleading, out of a court paper that I read 3 weeks ago in Republic of Georgia. Exactly the statement. These are not my words, but my client says. And of course his client wanted him to say it. There's no question about that.
He wants me to say it.
He wants me to say that the other side's lawyer is bribing the judge, and they are corrupt behind this.
Some evidence?
I don't know about the evidence, but it was a statement in a pleading to the very judge who was being accused of the bribery, of accepting the corruption. This was actually a question of the Ethics Commission in Georgia. They were asking me, what do I think should they punish this lawyer? You want to listen? Think. What do you think my answer might have been?
Without any more information
I understand.
about this,
And the lawyer may feel like he does believe it's true.
Yes.
Okay.
But did you file a complaint against the judge, or
No, not yet, at least. That
So
lawyer
was
had.
it first, and we don't have any.
No, instead what happened was the lawyer being accused filed a complaint with the Ethics Commission against the lawyer who made his client's statement.
For me, important is if there is some information about the.
Okay, some substance to it.
Substance.
Okay.
If there is a substance,
All right.
it could be
Okay,
okay, or more
Okay.
questionable if it was a first pledge to do.
with no foundation of any
No
kind.
foundation.
Okay. When you say some basis, though, do you mean that there has to be enough evidence that you will believe it at the end, or just some evidence that a reasonable person somebody might believe it? Which would be enough for you?
Definitely, if I will be convinced.
Sure.
But I will also, because of matter of freedom of speech,
Yeah,
let's say,
you might-
and interest of my client,
Okay,
if there are some substance
okay.
which could lead to this,
Okay.
opinion,
Okay. Do you think it matters that the lawyer was saying, these are my client's words? Or would it be the same issue, one way or the other, punish or not punish, same issue if it was the lawyer's words? Does it matter?
I think that there is a difference.
Okay.
Okay.
How does it make a difference for you?
I think, in my opinion, if the client really wanted to say that statement, and only made it with or through his advocate, it is not the same as the situation if the advocate made this statement on his own.
Okay.
Because
Even
he
if
wanted to, it was his legal opinion which he wanted to present before the court.
Okay, even assuming there was the same level of basis for it, no difference of basis for it, it either satisfies or doesn't satisfy Rita's basis standard. It still matters whether it's the lawyer's words or the client's words that the lawyer simply uses. Okay, tell me how. Tell me why it matters. I heard you say it matters, but why?
Because I think as a lawyer, as a part of justice delivering in a broader sense, people will more believe my statement.
So it has more impact.
They will believe me more than my angry client who was upset by something.
Okay, so it diminishes the impact of the statement if you are quoting your client instead of making the statement yourself. Okay. Anybody else have an opinion on this?
Client is not bound by the professional code.
No, the client is not, but the lawyer is, and so if the lawyer uses the client's words, is he still kind of bound at that moment or not?
It's different to me if he just communicates the words of his client.
Okay.
Accuses
Okay. All right. Anybody else have an opinion on this one? I told them at the end of the day that what really mattered was if they concluded that the lawyer was acting in the best interest of his client, legitimately furthering the client's interest, and there was enough basis that some reasonable person could conclude it. Maybe they wouldn't think it was true, maybe they would, but it wasn't unreasonable to think it, given the basis. If those two things were true, I said that the lawyer should not be punished. And what I was really doing was having, in my mind, a competition between a professional's duty to other professionals, because that's who he's insulting, right? And they were mostly focused on punishing him because he was saying insulting things about other legal professionals. That's what they were focused on. And I was having respect for other legal professionals compete with the duty to your client to advance your client's interests. And for me, advancing your client's interest wins over the duty to be nice to your fellow legal professional, as long as you really are advancing those interests and as long as there is at least some basis for it. And so that's how we had this conversation for quite a long time about this case at an all-day meeting where we spent a long time talking about a number of issues that they wanted to talk about, some of which were...
In my comments, I shifted to the judge, so
that's
more serious. But
exactly. All right, okay. So criticism of other legal professionals is a really delicate matter that's treated with a lot of emotion in professional lawyer and judge circles, I find, in a lot of different places. There are groups of lawyers, groups of judges in particular countries that think they should not be allowed to criticize one another except in private. Never allowed to criticize one another, even when it's true. Because they are members of a very important club, if you will. And they should not kind of hurt each other in that way. I disagree with that personally, because for me, the professions need to be connected to everybody else in the state, everybody else in the public, right? And shouldn't be closed societies in that way, where they protect each other more than they protect their clients and things like that. So for me, it's a competition with the protection of client. One of the judges at the forum last night mentioned something that I've always found very interesting that exists in the French legal culture, and I forget the French phrase right now, so I apologize. Maybe somebody in the room knows it. But it is possible, it is permitted for one French lawyer to send a communication to an opposing lawyer in a case and make this notation on it. And what it means is that the receiving lawyer is not permitted to share it with that lawyer's client. It must stay private between the two lawyers and cannot be shared with their clients. And American lawyers go crazy when they hear this. They go absolutely mad when they hear this because they think they have to tell their client things that the other lawyer tells them, that they have conversations, and that they should never respect the other lawyer more than they respect their client. Right? So culturally, it is just not any place that they can go in their minds in the U.S. But in the French system, they do it. And there are a number of other countries where that same thing happens. And one of the judges last night was talking about it.
And what do you think about the situation when I rephrase what was sent by my colleague from the other side?
For my client.
For my client, because
I think it's fine.
Because sometimes I feel that the content is okay and we can reach some agreement, but
Sure.
if it will be in this form, it will not work. So.
Right. It goes back to assisting my client, I think, at that point, right? If rephrasing it in a way that gives him the substance.
Yeah, he apologizes. It was not
Whatever, right? But gives him the substance, but perhaps removes the emotional part that might create an impossible settlement situation. I think that's appropriate. Okay, criticism. Public statements by judges now about their pending cases, not criticizing lawyers, but public statements by judges about a case that is right now in front of this judge's court. And we're going to do this on kind of a timeline and see how we feel differently about it in different time settings. So the judge is hearing evidence in the case. Should the judge make any public comment during the case about it?
I think that during the proceedings, the limit should be really the most strict, because when a judge makes some public comments about the case, he can express his relation to the matter, and it can make doubts about his impartiality.
Exactly, because the evidence is not in yet, at least not all of it. All of the arguments have not yet been made, and so it leads the public to think
But
he's not impartial, that he has decided before he has heard all of the presentations, whether it's evidence or arguments of one kind or another. So it's very risky for the whole justice system when judges make comments during the proceedings about the case.
And I think that also comments about lawyers during these proceedings can be very risky.
Yeah, because now we will all draw the conclusions about what the judge thinks of this lawyer or that lawyer. Now, having said that, sometimes it's impossible for the judge to avoid making comments about a lawyer during a case. Maybe not to the media, but if it's an open trial where anyone is allowed to attend, there will be media in the courtroom itself. And there are times when the lawyer does something that the judge must criticize right now, cannot wait for tomorrow or another day to criticize the lawyer for doing what he's doing, right? And so there are practical aspects of this that we can't avoid a certain amount of statements during the case, but at least they are in the courtroom. They are in the official kind of proceedings, and that seems much more acceptable and proper and so forth. So notice what I do. This is a teaching moment, I guess. Notice what I do whenever one of you says, that's improper, or I would punish that. What do I do next all the time? What do I keep doing over and over and over?
Pointing out some exception.
I point out exceptions, or I ask you another question, which is usually some form of, why? Why? I push you, I keep pushing, and it's good to push your students, right, to be able to explain why they have the position that they have. And in our setting, with professional norms, with professional ethics, the place you're always going back to, eventually, is what is it about what makes a good judge that causes this to be a problem? And you went to it immediately just now, impartiality. Right? It creates a public perception of taking sides or failing to be impartial. That's harmful. Great answer. And so I'm always doing that. And as a teacher, I'm always doing that with my students. You know, they want to say, this is no good. I say, why? They try to tell me, I say, tell me more. They try to tell me, I say, what does that have to do with being a judge? So I keep pushing until they make all the connections. Because when they make all the connections, they are better equipped to leave the room and make good decisions about the next thing they hear, or the next thing that happens to them in their professional life, if they're already lawyers or judges, or as they're going through school, they're learning and learning and learning. So I just wanted to stop and notice that I'm always doing that. How about after a case is decided? Should a judge have an interview with a reporter who wants to ask the judge questions about why the judge decided the way the judge did? What do you think about this one?
It's part of the judge's legitimacy.
Okay.
Judge's decision.
Okay.
Explain to the general public why it was decided this way.
Okay. All right. So it's a good thing.
Yeah.
Okay. It is strictly prohibited in Slovakia, for example. That just give you one example. Some judges still do it, but they regard judges who do it as being utterly unethical to speak to the media about even a case they've already decided.
But it doesn't make sense because the main reasons should be in the reasoning of the decision.
Right.
So what's the difference when the judge just says it publicly, maybe in most transparent way, or...
Yeah. So we should want the judge to be
Yes.
open with the public about the reasons they decide a case.
Yes.
So rather than punish them, we should, give them an award at a luncheon sometime, for being more transparent, right? Is there someplace in the middle? Is there a middle choice between prohibiting statements about why you decide and praising media statements? And I focus only now on media statements of why you decided. Having an interview with a reporter that'll be on the television or something like that. Is there a middle place that has, kind of favorable parts?
I think, in my opinion, some middle position is possible, but the judge should always be let's say, in a restrictive mode.
Okay.
With providing the public with some more information that extend the decision itself.
That extends beyond the written decision, is what you're saying
the written
now.
form of the decision
Exactly.
itself, yeah.
Okay.
I think. This is very risky and I think very controversial topic even now in the context of Czech legal culture.
Yeah, I'm told so.
nowadays.
Yeah. So how thorough are the written decisions of judges in Czech Republic? How carefully and thoroughly do they explain why they decided? Do you all read judicial opinions? Do you read them?
There are
Okay.
various attitudes.
Some are better than
There are
others.
various attitudes.
Some judges are better than others, you mean, at explaining? Okay.
It's very often you can have 20 pages, but the reasons are in 2 paragraphs, and says the truth is that.
Yeah, so volume is not the question, right? Right? Volume is definitely not the question. It's thorough, clear explanation of the reasoning, the rationale.
And which reacts on your argumentation or other side argumentation, so to explain why it's better argumentation this one than that one. So
And why the judge believed this witness and not that one, or this evidence and not that one, or things of that nature?
And what comes out of the evidence, what fact base.
Okay.
It's not usual.
Okay. What if, right? What if judges were taught and all did a good job? They won't all be perfect. No one will ever be, all perfect, right? But all did a good job of explaining in writing thoroughly why and how they decided the case. And of course, it also has to be easily accessible, right? Whether that means on a website or in a library that's easy to go to, it depends on the society, of course, but accessible, for sure. What if that were true? Would you feel differently about judges talking with reporters?
I think there is a point, because if the judge is willing to talk to the reporter, he's just appearing to be more transparent.
Okay.
He's willing to explain.
Okay.
So there's nothing to hide.
Okay, and that's the positive of it, right? Is there any negative? Again, assuming this world in which judges write thorough opinions in the first place, or decisions. Is there a other side to it?
As the reporter asks questions and the judge has to respond live, there can be some discrepancy on the written decision, and he can say something he would like to, he wouldn't like to say.
And suddenly there's confusion about...
And it's just...
Yeah, so this is the trade-off, and it's exactly the trade-off that exists if you have judges who write thorough decisions, right, in the first place. Then the trade-off of having them do media appearances is the trade-off between being even more accessible to the public, open to the public, and the like, which is a good thing, and the danger of creating confusion, because anything I say out loud might not be as carefully worded as what I did in writing, if I've done it carefully in writing. And it can only create confusion if there's difference, right? So some judges in some parts of the world are prohibited, as I said, from making any sort of media appearance about a case, even one that's decided. I think that society has concluded that this danger is very, very great. But frankly, most of those places that I've experienced, the judges don't really write good opinions. So they never explain themselves. And that may be the worst of possible systems, where the judges explain themselves neither in writing nor in public to media. Because what do people believe when that happens? What is left for the public to think when the judges won't explain why they decide the case the way they do? There's something bad behind it. If I'm not allowed to know why you decided, right? If I'm not allowed to know why you decided, then I mistrust why you decided. It's just natural. And it may not be the case, of course. It's not the case that there's corruption in every case and all the rest. But it is true that that's the conclusion that people draw if they don't get an explanation. I think this is true in our daily lives. Have any of you ever been required to do something by, it could be your superior, it could even be by your spouse where you've had a discussion and now somebody insists we're going to do it this way, a parent, whatever it happens to be. We've all, right? Don't we all feel better and trust that person more if they tell us why? We are all more willing to do it, even if we disagree. Right? We might disagree with their decision, but if they tell us why, sort of in good faith, why they did it, we feel better about it. I think this is true. And I think the same is true for judges and the public, and the litigants too, but the litigants, the lawyers, and the public. And so this question of media appearances, I think, should be treated very differently in places where judges are willing to write thorough opinions, where I would tend to discourage them from then talking to the media, because it's there. They can say to the media, my opinion is 20 pages of serious reasoning. I've said it the best I can. I've done the best I can in writing. Read it. And then report on it. Go ahead. Tell the public what you think, if I'm good or bad. But here it is. This is the best I can do to explain it. But it ought to be treated differently, media appearances should, in places where judges don't write. If judges aren't willing to write, they should be willing to come out of behind the curtain and explain themselves. Right? But for my preference, I much prefer systems, and I advise judiciaries in different countries, I much prefer systems where the judges write and take their time to express themselves correctly, carefully, and then basically say to everyone who wants to ask them questions, I've done the best I can, here it is. Here are my 20 pages. Yeah.
I think the reason for these prohibitions to the judges may also be
right.
The idea that no one has the influence on the media what will be included in the report. So there can be some cuts and of the speech of the judge. So it's great danger.
It is dangerous and risky, and it takes a very, very talented person, and not the same talents as make a good judge or make a good lawyer necessarily, a very talented person to be able to deal with the media successfully and not find themselves taken, out of the context or have quotes.
But sometimes the higher courts, they use press releases.
Yes.
So from these 20 pages to make a one-page
They do.
basic explanation what this was about. And
It could be an effective system.
Yeah, so at least something because no one will read the whole thing.
Yeah, it can be an effective system. Again, I think systems work well when the judges write a lot, thorough, complete explanations. They are easily accessible. You can get them on the web or some, easy indexes and things like that. You don't need to know secret things to find them, right? There's some places where all the decisions are on the web page. But if you don't know the case number already, you will never find it, right? I think this is true some places. So they have to be accessible as well as, thoroughly written. And then, press releases can be helpful. And journalists, it develops in such places where the judges write well that journalists develop pretty good expertise at reading those opinions and telling the public about them in a pretty good way. I mean, they're not perfect. No one will be perfect, but in a pretty good way, they are able to communicate those kind of things to the public, which is very, very helpful at that time. All right, let's move and talk. There's a lot more we could do with that, but let's move and talk about advertising for a little bit. and it'll mostly be about lawyers, for sure. What's the danger of having lawyers advertise? In most parts of the world, for a long time, it had been completely prohibited. In some parts of the world, it's still completely prohibited. Slovakia is just changing now. They have some new system coming into place, but until very recently, the only advertising a lawyer was allowed to do was the plaque on the lawyer's building or wall or place. And the rule was so specific that it said how many centimeters could be the plaque. Right, so it's very, very restrictive. Lawyers in the U.S. in the 1930s, 40s, 50s were punished by bar associations when they would put an ad in the newspaper, and all the ad said was something like the lawyer's name, address, what kind of cases the lawyer does, and then would have maybe some phrase like first meeting free. This was the offending part. It was advertising. It was meant to promote people to come to me instead of you. And this was punished by bar associations in the United States until the 1970s and 80s, when all of that changed very dramatically because of some free speech cases that the Supreme Court decided. So what do you think? What is wrong in the first place with having lawyers advertise at all?
Force ordinary people to start court cases and then rules.
So people will start court cases that they shouldn't start. It encourages silly litigation. It encourages bad litigation. Okay, that's a possibility. Does anybody think that's not really a danger?
It could be depending on the ad, but I think...
Oh, if the ad said, I start silly litigation, that is my business, come to me.
I think if it said like sue your family, it's the right way to like get money.
Okay.
It could possibly discourage people of mediation or just settling disputes.
All right.
But probably there are many reasons on the level of professional interest. Some more idealistic, like if we prohibit much advertising, we'll just recommend the good ones. And on a more practical way, if there is more advertising with disclosing prices, it just worsens the market.
So advertising for price is risky, you think?
Well, for the professionals,
because it's better for clients to not know what the price will be.
And the price go down. So.
Okay. Okay. Others? What do you think?
I think that it's okay. It's service like many others. Why not let them to advertise?
Okay. So it should be treated like other businesses, which are also regulated in their advertising statements in some ways, right? I mean, what things generally do you, and maybe somebody's an expert in the room on, competition and things like that, or advertising law. What are the normal limits on advertising of a business? Not for just lawyers, but generally. What are the normal limits?
Other businesses shouldn't be named directly.
Okay, there are some places where you're not allowed to name other businesses. Yeah, and whenever we have friends come to the U.S. From other countries, they are shocked when the cell phone companies, for example, the mobile companies, right? Their advertisements constantly say, "Our service is better than Verizon." Our service is faster than T-Mobile service, or things like that. And they all go, "Whoa, they can't do that." Right? So, okay, that is a common restriction in some parts of the world. You're not allowed to name your competitor, right? You can't identify them by name.
It's also the more general question of the culture of the country.
Absolutely.
So if you want to have a more competitive, more business-oriented legal culture, or culture of barristers or advocates, or some different. So it's I think it's very much a cultural issue.
It is. For sure it's a cultural issue, and I will show you one advertisement that I think you will at least think is a culture you might not want to belong to, but that's okay. But what are the normal restrictions on business advertisements? Are there?
False information.
It has to be true, right? It can't be false or misleading. The normal restrictions that you find in most countries about advertising generally, other than the detailed ones, there are some places, I agree, but the broad application is you can't make statements that are false or misleading, and you can't advertise an illegal product or transaction or something, right? You can't advertise that you will break the law for someone, right? Those are the two normal ones, right? And in the US, after these decisions of the 1970s and 80s of our Supreme Court, that's actually all that's left of lawyer advertising restrictions. Now, there's some small things, like if you send a direct mail to someone, which we're allowed to do, lawyers are allowed to send a piece of mail to somebody that they want to recruit as a client. There are small restrictions, like they have to put the words advertising material on the envelope, so that at least the person is aware that's what they're getting. They're not getting some official document from a lawyer or something like that, right? So there are small things like that, but in a broad sense, the only restrictions left in the US on lawyer advertising are that it can't be false, misleading, or advertise an illegal product, and we still have one other, it can't be face-to-face. Okay, we also still restrict the idea that I could just walk up to you and say, I see you have a broken leg. Did it come in an accident? Maybe I can help you. I could be your lawyer, right? Or follow you in the ambulance to the hospital after the car accident. So we are not allowed to do that either. We call that solicitation. That's the word used for it, rather than advertising, which is a more general kind of statement of being available for this kind of business. But what are the dangers? What are the other dangers that you worry about? Should professionals advertise price or not? Is it a good thing or a bad thing?
Well, I'm not against. I said some reasons, but my personal opinion is I wouldn't restrict advertising very much.
I think
these days.
I think that in practice, I don't know any legal office or advocate office in Czech Republic that adverts prices for legal services.
Okay.
No, they are on websites you can find.
It's
interesting for me.
Yeah, I thought so.
Because
we don't have it, but
because usually it depends on the solicitation with the client on the price.
But they have sometimes they have our fee is 2,000, or depends on the matter, but starts on this point and goes to 3,000
for a particular kind of matter. So you might say if it is a simple divorce matter or something like that.
Or the more specific, I saw the divorcement for 3,000. Sell agreement on a piece of land for 5,000.
Okay, so good or bad. This is true in Czech Republic now. We have it on good authority that this also happens here. Is it good or bad for lawyers to advertise their prices?
Nothing bad.
It's not bad.
I don't do it because I don't think
I understand.
it's good for my business.
But you don't think it's a bad thing for the profession or the public?
Yeah,
okay. Anybody take the other view?
To me, it's just a fact because in the age of the internet,
it just exists.
Couldn't force them not to comment in some forum and
Okay. When these important cases were decided in the U.S. in the 1970s and 80s, the bar associations wanted to punish lawyers for advertising price. There were lawyers who decided they were going to have, what's the best way to say this? They were going to have a volume business rather than a high price business. So they wanted to do a lot of drafting of wills for people, doing divorces, doing adoption, you know, relatively simple things, but a lot of them at a lower price. So they were going to be a little bit more like a Tesco or something, like a big store rather than a small neighborhood store, right? If you could think of it that way, right? And they realized, these lawyers realized that they would fail unless they could get a lot of people to come in the door. They wanted to do a lot of these, and there were people on one side of this debate who said, this is horrible to have lawyers advertising like they're a Tesco store or a Walmart or, you know, something like that, right? It's terrible, it's demeaning, it's our dignity as a profession that we're losing. People on the other side were saying things like, this is great. There are going to be a lot of people who get their will drafted who would never in a million years have gone into a normal lawyer office when they had no idea how much it would cost, and it probably would cost 3 times the price of this volume place, right? This other place. They would never go. So it's a good thing for the public that lawyers make services available to more people. And you can see how that debate could develop. And it developed in a very prominent way. It was very interesting culturally to see the decisions of the Supreme Court on these cases when they made it to that level. Because this was a period of time when consumerism, this kind of idea that, you know, consumers should be cared for in a better way, was a very popular idea. So car safety issues were being raised, and car manufacturers were being required to put safety belts for the first time, and, you know, all sorts of things like that were happening at the same time. And the Supreme Court's opinion in the first big case is very interesting to read, because what you realize is they are more focused on the public's right to know information about lawyer services than they are about the profession's interest in keeping its dignity strong, right? They really kind of, they disparaged the idea that the profession should be able to keep its dignity up if that was going to prevent people from learning things about lawyers. So it was a little bit less about the lawyer's right to say their price and a little more about the public's right to hear the price, to read it in the advertisements. It's a really interesting decision. So all of that got wiped out overnight. Now, does that mean that all lawyers advertise their price in the US? Of course not. It means that lawyers have made business decisions about what kind of practice they have and what promotion of it is important to them. So you will never see Baker McKenzie or, you know, some of the big international law firms, right? The big New York firms and Washington firms, Arnold & Porter and so forth. They're not going to advertise price, right? And their website, if you look at it, it's very interesting to look. Their website looks completely different from the website of a small local practice, and it also looks completely different. If you want to look at it, you can look at it. It looks completely different from the website of some of the new forms of legal services delivery that are now permitted in the UK and in Australia. So in the UK now and Australia, it is now permissible for people who are not lawyers to own legal services delivery. It means that Tesco could, if it chose, have a law department. There could be an aisle in the Tesco store. This is coming, don't laugh. This is coming. There could be an aisle in the Tesco store with boxes that have the information about a will, drafting a will. The consumer would go to the box, buy a will, and then go to see a lawyer who works for Tesco, right? Like they were insurance salesmen or other, like I don't know what you have here. In a lot of big department stores in the US, there might be a hair cutter. There might be an eye doctor. There might be, not dentists, they don't do that. But there are other service providers that are right there inside the, the big store, like a Walmart or a Tesco or a Sears, the old Sears stores. So there could be a lawyer booth, right? Where you would go with your box, you bought it off the aisle, and you go and this lawyer helps you make it work for you. And you do that for a much lower price than if you went to a traditional law firm to get that done. That's happening already in the UK. There's a very big UK company called The Cooperative. I don't know if any of you have ever heard of it. You've heard of it. What kind of things do they sell? Do you know?
They also sell everything. They start with food. They provide also some no food items. It's
Yeah.
družstvo. Cooperative.
It's a cooperative.
Yeah,
They
yeah.
sell funeral services. They have 20 different businesses that are owned by this company, are all service providers. And there is now something called the Cooperative Legal Services. And they sell legal services. And their website, you want to look at it? Okay. Their website does not look like a law firm's website because they are selling a different product. Right? They are selling legal services for regular people. And they are selling it in a way that is attractive to regular people. Can I just use this? You think? Do I have to turn that on or something, right? Didn't we have a problem yesterday trying to... What do we do? You were the expert yesterday.
I wasn't.
I thought you were the expert yesterday.
You are expert.
Okay, so it's going to warm up over my head now, right? All right. Great.
It's there.
Come on, go there.
It's there. Oh.
Yeah, but it's not going to my website. Do I need to tell this yes?
No.
Okay.
No.
Oh! I do know yes and no in Czech, but I didn't know if I needed to tell it yes or no. All right. So if I hit enter, we should go there, right? It won't let me. How come? Cooperative Legal Services should bring their website right up.
Internet si zapnutý? Dole?
Já jsem myslel, že tam je mít certifikát.
Síť nějakou případu.
Tam je
Zkus kliknout na tu síť.
Uh-oh, we're not on the internet.
No, na tomu ne, to jsem přihlásil.
Now I see the problem. Maybe somebody needs to log on.
No. To musí dát heslo někdo, ale to na to.
Když je to připojeno, tak to znamená, že...
Aha, you're getting there, right? We'll see. All right. Good. Did you? Yeah, you hit it. Okay. Does this look like a law firm website? So how many of you have looked at a big law firm website before? Okay. Does it look like one? No. They're selling a product to young families with children who go to parks and enjoy their Saturday time off together. Are big law firms selling to those people? No, of course not. I mean, Kinsteller doesn't sell to those people, does it? Huh? I'm not criticizing them. They just have a different market for their services. It's just, okay. All right. let's actually go. Yeah, so you see the kind of things they do. They do probate, which is settling of estates, wills, family matters, personal injury, employment, and conveyancing. They do the kind of things that folks need, right? They're not doing corporate mergers. That's not their product. And this is the way to sell it. Legal advice without the jargon. The fee we quote is the fee you pay. They have slogans, right? They have slogans. Let's see. Big pillars. Very big justice pillars. That's about it. Let's try somebody else. How about, let's see. Anybody have any that you? Alan Overy. Brexit is on the. So this is not typical either. I have to tell you that most of the ones that I go to are these guys. It's mostly just old white men on the big law firms pages. And then they have, you know, some token diversity, but it's mostly old white men on the pictures, and they have very, very nice suits, much better suits than I have, and much better haircuts, very, very good haircuts. That's usually what you see. All right, but anyway, if you go to the websites of law firms or legal services delivery, you find out a lot about who they are, what they're trying to sell, and how they're trying to sell it. Their marketing is a big part of their work today. Lawyers' marketing has always been a big part of their work. Traditionally, lawyer associations, certainly in the US and other places I've been, have said lawyers should not advertise their product, traditionally, should not advertise their product because we are a profession and not a money-making business. We are not a trade, a money-making trade or something like that. And I've always thought that was a little bit silly. Because most of you probably would like to make a living, and you know, the students I have all over the world, they hope to get a job where they get paid, and if they open their own office, they hope to get paid by their clients. You know, so it is certainly a very important, fundamentally important service that we're providing. We're managing the justice system in our countries, and so you can't do without us, it seems to me. At least in the parts of our work where we are, you know, this core aspect of how justice gets delivered to people. So it is a very important service. It's not just like plumbing, but plumbing is important too. But it is still a way to make a living, and I think that's not something that, as a profession, we should sort of be embarrassed of or look down on. And it's just always been true. That's not quite fair. In the UK, there was a time in the Middle Ages when advocates were people who were already noble people, wealthy people, had no need actually of income, and they did advocacy sort of as an honor or a hobby, not really to make a living. But certainly in the US, since colonial times, people went to be a lawyer because they would make a living at it. Not that they would be richer than everybody else, but that they would at least, you know, earn a wage and be able to support their families and things like that. And that's shouldn't be sort of something that we pretend is not true, it seems to me. Instead, look at the websites and figure out how they sell what they're selling. I mean, they are promoting their product. Even the most traditional firms are doing that. Anyway, okay. So do you want to see a kind of, sure you do. Is it loud enough? That's all I've got on there. Can you hear it? Can somebody make it louder, because you can't hear this? I'll go back. Don't worry.
Based in Pittsburgh, Pennsylvania,
Great.
and I stand ready, willing, able, and...
This is way better than you can hear it.
Thanks, Dan! Thanks, Dan. Thanks, Dan. Thanks, Dan. Thanks, Dan.
Thanks, Dan.
Thanks, Dan. Consequences. They sure suck, don't they? America was built on freedom, not on a bunch of people with more money than you telling you what you can and can't do with all their stupid laws. Laws are arbitrary. Hi, my name is Daniel Music, and I'm a criminal defense attorney based in Pittsburgh, Pennsylvania, and I stand ready, willing, able, and committed to defend you on all manner of criminal charges, including murder, arson, burglary, bank robbery, simple and aggravated assault, and possibly even funny throwback crimes such as moonshining or pickpocketing. When you're charged with a serious criminal offense, you're facing the fight of your life. You need a lawyer who understands you and understands where you're coming from. Trust me, I may have a law degree, but I think like a criminal. Street knowledge. A lot of criminal defense attorneys around town are going to take your money and then blow you off. That's not me. I pick up the phone, I answer calls, I return letters, and I make jail visits. because I'll probably be there visiting my friends anyways. I'm the Pittsburgh criminal defense attorney Pittsburgh criminals hire when they commit crimes. I'm also licensed to practice in every single county in the Commonwealth, so don't feel left out, people in Beaver, Mercer, Crawford, Venango, or even Lehigh County. I'll go anywhere. Any criminal defense attorney who promises you a result is most likely a liar or a scumbag. And what I can promise you is my committed fighting effort to ensure that you are adequately defended on any charge that you're facing. Pay me now, thank me later, and remember, you keep your trap shut, and I'll keep your trap open.
He's not quite done. So this is not a typical American lawyer ad, I want to say, but it is a real one. It's not made up. It's not for John Oliver. Somebody. Okay, I don't know what else we're going to do. I better get rid of this, I guess, right? I don't know what's going to come on after that. What do I want here? All right. So not a typical American lawyer ad, but it's a real one. It's one that actually airs on television in Pittsburgh, Pennsylvania. What did you think? Can't believe it, can you?
There's nothing to do with ethics, you know.
Well, what do you mean by that? Nothing to do with ethics.
I think that how can I say it? This is the way to maybe how said about it. How can I repeat it? To saying something to committed crimes because it's not problems. I can solve it.
Ah, okay. So he's encouraging people to commit crimes.
Yeah.
You think? Okay. All right. Okay. Let me ask. Do you think it's effective in a business sense? Do you think he will get more clients?
I don't know, but maybe maybe more clients, but I don't know how much money they will have because I think it will be target for lower classes, social classes.
Sure, that's who commits the crimes. That's
Yes,
that's his target audience. I mean.
Yes, and I think that the better business plan will be to focus on some companies or.
Oh, okay, okay, yeah,
like
he probably can't compete with Arnold and Porter.
Yes.
So he's not trying to do that. He picked out a particular market and a particular service, and he's trying to reach it. So the question for me is, I'm curious to know what you think. You have to try to imagine yourself a criminal in Pittsburgh, Pennsylvania, which might be hard for some of you to imagine. But do you think it will work? Do you think if you were charged with a crime in Pittsburgh, Pennsylvania, this ad might motivate you to go to see this guy?
Yeah, sure.
Yeah, you're okay with
If I was a criminal, I would go because finally someone who understands me. You know, lawyers, they are so remote. I mean, if I'm a criminal and I'm meeting a lawyer, oh my God, it's another world. How can I trust this guy? And this guy is saying, I will do the best for you. So, and I understand you. Maybe you had it hard in your life.
Yeah.
It's great. I really appreciate this ad because it's just, you know, it's something like fallen from the heaven out of blue, and I'm quite shocked. But on the other hand, you know, I think that legal service is still service, and if your target audience are criminals, why not?
Anybody else? Yeah.
Well, I'm not sure from a marketing perspective if this is the most effective way. I think if he engaged in some real street work and just approached his target audience, it could work better. I'm not sure if this was aired on TV or.
Yes, for sure. Aired on the television station, local television stations.
Okay. I'm not sure if the gang members watch.
Okay. So you're not too sure whether that's a good vehicle for getting the message to them.
Yeah.
Okay. Okay.
Maybe for me as a criminal.
Yeah.
Criminal,
Right.
I would like to be represented by a lawyer with good reputation, because the court will be decided on my guilt or
Okay.
theory or something like
Okay.
that, and this guy doesn't have.
You might want somebody more dignified,
Yes, yes.
who you think is going to be respected by the judge more. That's a reasonable response to it. Yeah, right. You're all trying to be criminals in your minds right now to see if you can picture whether this is good business or not. What do you think about the ad? So we've been told one reason, possibly, maybe it encourages people to actually commit crimes. Okay, and if that's the case, we should prohibit it, right? If we actually came to the conclusion that it encouraged crime.
Or it's at least saying that crime is normal, like, I don't mean for even normal people.
Yeah, okay. But okay, should we prohibit that? If the message is, you know, normal people commit crimes, and if you do, and you're a normal person, and you need representation, I'll be a good lawyer for you.
You know, I think that it's depends on the type of presentation of your services, and I think that this type of presentation not corresponding with dignity of advocate or something like that.
Okay, it hurts the dignity of advocates.
Yeah,
It for sure does. So I have to tell you, one of the explicit statements in these Supreme Court cases from the 1970s and 80s said, the legal profession cannot any longer prohibit ads that are in poor taste, that are in bad taste, that are undignified. So that has been wiped out, at least in our system, that you cannot, the Bar Association cannot stop a lawyer from acting in bad taste, as long as what he says is not false, you know, or as long as it is not advertising the commission of wrongful transactions or acts. Okay. Anybody else?
I think there is a part of this is, or principle of this advertising is also humor. So it's hard to assess that just as a message. It's also a humorous message. So
Yeah. So why does he make it humorous? Do you think?
I think it's over.
Better for watching, though.
It's to be remembered. It's to be sort of fun to watch it, right? What kind of products do you buy in life? Do you buy in life products that you've seen advertisements for or not? Anybody buy anything that you see an advertisement for? Sure, of course you do. What kind of ads are appealing to you? You know?
I have a daughter, you know, you've met her.
I'm sorry?
I've got
Your daughter, yeah, your daughter.
And then you get these children's channels where, you know, it's always disturbed by the commercials. Like
Yes.
by fairy tale and then, you know, some kind of advertisement.
Yeah.
And obviously she wants everything she sees then. What they say in the advert is, oh, this is for you. And then she goes to me, oh, look, this is for me.
So what kind of products do they advertise on those shows?
They're very clever the way they advertise, you know, things to children, for example.
Of course.
And you could, I haven't seen that ad, you know, I haven't seen what you presented. But I can guess that, again, the lawyer is trying to approach a wider, maybe more general audience, you know.
He's got a very particular audience in mind.
Yeah.
People who have committed crime are the audience for him. They're the ones who need his service.
Perhaps some petty crime, or was it?
No, he says everything from murder down to... So, you know, the long-time debate about advertising by lawyers really does come down to whether, you know, you favor having a profession that is separate and dignified and different from other kind of businesses, or whether you just simply think, you know, it is a service that we're providing. It's a critical service, a fundamental service, but at the same time, it's one that is part of the marketplace, right? It's part of the marketplace, and we've just looked at some, you know, websites for big law firms that are selling a product to big companies, And this guy is selling a different legal services product to not companies, but individuals of a particular group.
My question is why the dignity is so important.
Why is dignity so important?
Why is
okay.
Again, which purpose serves dignity as a value for the society,
or is it just ours? It sort of belongs to us. It makes us feel better.
We are better than others.
Yeah. So you clearly would not favor.
Sure, I like it very much, but I think why, and of course, if it's not push people to commit crimes,
sure.
Then okay, I will not buy these services from this man because it shouldn't seem reliable for me. But okay, if someone wants to try.
Yeah, right.
I have one more comment
sure.
on this ad. I've got feeling that if you hire this guy, you are claiming I'm guilty. Look, I'm guilty. You know, it should be proven during the case, during the proceedings. But if you hire this guy, I committed this crime, but I want to have the lower sentence as possible, or
okay, that's interesting. That you're identifying with the dramatizations at the beginning. All people that we watch commit their crimes, right? We're watching those guys at the beginning commit their crimes. So maybe you are identifying if you're a client of this guy, you might be identifying yourself with those individuals. I can imagine that. I will say that older members of the profession by age, I know I'm old, but older members of the profession, and especially older judges, hate these advertisements. They despise these advertisements. They will come at it seems like every time you go to a bar association luncheon for some purpose, there will be a speaker who gets up afterwards and complains that the profession has been ruined by the Supreme Court by letting it be like any other business. That is a very, very, very common theme of old lawyers, right? And I understand I'm old, but so there is some risk. I will actually identify with what you said earlier. I think there is some risk that hiring somebody who does an ad like this will hurt you in front of judges, certain judges. There is a certain risk in it. And at the same time, I'm definitely of the group who thinks we provide a critical service, but it's a service, it's a way of making a living. Why shouldn't we advertise? If his advertisement brings him more clients, but it's honest, I see no problem with it. And he won't be punished for that ad. He will not be punished for that ad.
You can try it
here. Yeah, good luck. Good luck with that.
I think there was remotely similar ad in the Czech Republic. I'm not sure how it ended. There definitely were some disciplinary proceedings concerning that. Maybe it was a series of videos on the internet, internet TV. Maybe it was called Devil's Advocate, I'm not sure. And there was an actor hired by some attorneys at it, and he was dressed so he looked evil, and he described some legal situations, but gave advice that was really on the very edge of legality.
Got it.
Like he advised that before marrying, you should already manipulate the other one to sign směnka.
Prenuptial agreement or something, or some kind of
very promissory note.
Okay.
Not a very dangerous kind of. And just in case of a divorcing claim, you want.
Got it.
So
oh wow. Okay.
I think it was.
Well, I would love to see that if there is such a thing.
It was. I think it. Well, it was made by the lawyer. I think he was in the credits, so in my opinion, it was sort of independent because you could make the conclusion if the actor speaks for him.
What else would you like to talk about? We don't have much time left. We're close to the end, but I've had a great time with you. I think this has really been enjoyable for me. I hope you've gotten something out of it. But I'm open to talking about anything that you want to talk about that we haven't talked about yet. Anything at all.
Maybe I could hear something about ads for judges' elections.
Ads for?
Judges' elections.
Oh, judges' elections. I could probably find that, John Oliver. Have you ever watched, do you know John Oliver? He's a comedian. He got his start with Jon Stewart on The Daily Show. I don't know if you know that one or not. He now has, John Oliver now has a show that goes on, I think it's HBO, from time to time. But all of his shows are meant to make fun of some condition in society that he thinks is a little bit crazy. But he did a show about judicial selection, advertising in particular, elections in the U.S., and it was very well done and very striking. If you ever want to look it up, it's an HBO show. It's John Oliver is his name, so that's easy to do. But it's a very difficult thing to know. The states, the U.S. states that have elected judges became states during a period of time when the prominent political philosophy was a very populist one, a very, very populist one. People should be in charge of things, okay? And so in the states, in those constitutions of those states that became states during that period of time, it was pretty common for them to have a provision that said judges get elected and set up the system for how they would be elected by the people. And so it's easy to understand how it happened, given that kind of political philosophy that was dominant at the time, the mood in the country that was dominant at the time. What it means is some really, really bad things, right? Like judges running for public office that way, judges running for their office, will make promises that are meant to gather votes for them that would cause thoughtful observers to conclude they are not going to follow legal principles or have good judgment. So they will promise, they don't promise to violate the law, but they will promise, for example, to give the harshest possible sentences to all criminals who come into their court. Right? They will say things like that. And they believe that gets them votes. I don't know if they're right or wrong, but when that guy gets elected, that was his campaign promise. And he, forms a reputation of being somebody who, if you are a criminal and you go in his court, you're going to go to jail a long time. So it causes them to make populist kind of
promises, things like, one of our, I don't want to go there, but crazy president nominees, presidential candidates is doing right now. They cause these people running for office to make these kind of promises, and then they're judges. And so we absolutely question their impartiality in terms of their ability to be fair-minded and open and consider all the arguments, because we think they've already promised us how they're going to react. Now, I don't know if anybody's done an empirical study to know whether judges who promise those sentences really give them. I honestly don't know whether that's been done or not. I'd be curious to see, but I've never studied.
Because there is an empirical study that studies connection between this financing campaign and
financing, yes,
and impartiality.
Yes, there is. Yeah, there is, and so that's the other problem. It's not just the promises that they make, but it's they need to raise money in order to run for office. They need to buy television commercial time, and they need to hire people who make their commercials and things like that. And where would you guess that judges mostly raise money for a campaign? Who do they ask for money?
Big companies.
Well, a few of them do that. If they are running for like a state Supreme Court, they might ask big companies for money because their decisions will affect economic conditions in their state. So it's a small number that are running for those very high judicial offices in a state, and they might ask for company money. But the local judges don't ask,
law firms.
They ask law firms. They ask lawyers to donate money to their campaign. And lawyers do donate money to their campaign. It is made public, so at least that part of it has to be disclosed who donated to your campaign. But nonetheless, it's a very dangerous practice, right? It's a very dangerous practice. And you know, it's not prohibited for the lawyers to donate money to the judges' election campaigns.
And how many states have
It's quite a lot. I don't know the number for sure. I would guess it might be as many as 30 out of 50. It is mostly not like California, but otherwise Western and big rural Midwestern states. Mostly, not all, but mostly those. So it's states that came into being from roughly 1860 or 65 until 1900, something like that period, right? So we already had, at that time, California, I can't remember if Oregon and Washington came in, but then the other parts of the West, like Montana, the Dakotas, Nevada, Nebraska, those states all came in that period when this sort of populist political theory was the prominent one. So there are many, many very dangerous things about it. There are some people who like it. There are some people who think it causes the judges to be more transparent because they have to publicize their opinions about social issues. You know, when you run for office, you get asked questions, and people say, what do you think about this topic, or what do you think about that topic? And if you're running for office, you answer. If you're a judge or becoming a judge in a more closed system where you don't have to be out in front of the public, people know less about you sometimes. The legislators might know more about you, or the governors might know more about you because they're the ones picking you, but the public will know less about you. So that people who like it, and there are some people who like it, say that all those bad things, they don't say they're not bad, all those bad things are outweighed by the fact that the people know who their judges are. So that's sort of the argument back and forth. I don't know if that answered your question or not. Okay. But if you want to watch more and laugh very hard, find that John Oliver episode about elected judges. It's very, very funny. And disgusting in some ways. Some of the ads are not just in bad taste, but really cause you to think this judge could not possibly be neutral. So it's very bad that way.
How was the name once more? I would like
John
to look at that.
Oliver, Oliver.
Yeah, I know this guy.
You know that guy? Yeah, he's a British guy, I think. At least he has a British accent. Okay. Anything else? Anybody want to talk about?
Just to pick up
sure.
There was advocate we mentioned the article Kingberg and the spy bridge.
Oh yeah.
I just like to add a name. Probably many know the case. It was after the Second World War. There was a Nazi official, Karl Hermann Frank, and there was big difficulty finding an advocate for him. So the one was in the end appointed by the Bar Association. His name was Colonel Ressler. And there was a big discussion yet. Big problem with defending Frank. Some of his relatives, I think, died during the Nazi period. But in the end, he defended him. There was a big public appeal against him, but still acted against according
For
to
him.
his role.
Yeah, yeah. I'll tell you one quick story about.
Sorry,
No, I
Thank you very
understand.
much.
Thank you very much. Bye-bye. Just about that same theme, there's a prominent organization in the United States called the American Civil Liberties Union. It operates to defend civil rights, civil liberties, and it has a team of lawyers who represent people who have human rights kind of claims and things like that, right? And their most prominent issue that they advocate on is free speech. Free speech, free speech, free speech. Very, very important, of course. So this was all the way back when I was in law school myself, a student. So dinosaurs were on the earth and all that kind of thing. It was in the late 70s, late 1970s. And there was a group of Ku Klux Klan, hate group, right, who wanted to have a parade. They wanted to be permitted to have a parade in a town called Skokie, Illinois, which was mostly a Jewish city, Jewish town, and they were being denied by the local officials a permit to have their march, to have their parade. And they definitely wanted to have their parade in Skokie, Illinois, so that they could have, messages that were about hating Jewish people. This is an organization that did horrible things, hate things to black people and Catholics, Jewish people, So they definitely wanted to have it there so that they could be kind of in the face of the Jewish community in this town. And it was a very distasteful thing that they wanted to do, right? And a significant part of the financial support, because the American Civil Liberties Union is a private NGO, it has to get donations, things like that to keep operating, very significant part of their financial support came from Jewish people. For a lot of reasons, historical. And so the Ku Klux Klan came to the American Civil Liberties Union for legal representation to try to get their free speech permit to have their parade in Skokie, Illinois. And after some, kind of very serious, deep conversations within the leadership of the American Civil Liberties Union, they decided that they had to put their principle higher than their own personal views of what somebody wanted to say. And they decided to represent the Ku Klux Klan, to represent their free speech interests, to try to get this parade permit. And it's a free country. People can donate when they want or stop donating when they want to organizations. And a very significant part of their donations ended at that time. And people who supported them for generations were furious with the American Civil Liberties Union, and they were so angry, and they were writing them letters and saying, how dare you, and you are so horrible to represent these people, how could you possibly do it, I will never support you again for the rest of my life, I hope you go to hell, and all the rest. The American Civil Liberties Union started because they believed in free speech. They started publishing the letters that they were receiving, 99% of which were very, very angry and hateful toward them. But in their newsletter, they published, letters after letter after letter after letter, hating what the American Civil Liberties had chosen to do, right? People saying, I hate that you've done this. It's terrible. Here I was as a student, and I belonged to the ACLU. I was actually on like a legal committee that would help decide local cases, not big things like that, but local cases who they would represent. And so I got this newspaper all the time, and I was reading, and I'm reading, and I'm reading, and all these angry messages, all these angry messages, all these angry messages. And then there was one, this one, that was in there, and it said, "I am enclosing a donation of $10, the person said. Defend the bastards." This person tried to say in 3 words, in, I think, poem. It's like a poetic way of saying something. You choose as few words as possible to convey your message. And this person was trying to say, yes, defend these horrible people. That's the right thing to do. And to me, that was just this amazing kind of defend the bastard was what I'm sure somebody was thinking in the story you're telling, right? He did it even though he thought the person he was defending was an absolutely horrible person, I'm sure. So that's my ending story. Thank you all very much for a really good day and a half. I know people had to come, people had to go, things like that. I understand you all have really busy schedules. I want to be clear that I passed out my business cards to all of you yesterday. Maybe I didn't, I don't know if I gave you one. Okay, I will. I did that for a reason, right? It's not just to give you a business card so I can have more printed. I hope to hear from you. Sometimes people that I've worked with in a setting like this think, oh no, I'm not going to write him an email and ask him this question or something. It'll be too much bother. He's very busy and this kind of thing. It's not a bother. I feel bad if I don't hear from any of you. Right? It makes me happy when I get a message from a group that I've worked with for a day or so. So never hesitate. Never, never hesitate. If you have something that you think I could help you with, help you find some material or, you know, whatever it is. If it's something I can't do, I'll tell you. You know, I can't do it for some reason or other. I don't know enough about that. But if I can help you, I will help you. I promise that. So use my business card. Okay? All right.
I can confirm it works. I tried.
So thank you to Pro Bono Alliance. Thank you to Masaryk for hosting, and I think we're done.
Great. I just have one more question.
Yeah, sure.
Participants, just tell me if it meets your purposes. If the workshop was what you.
Oh, not in my presence. You mean tell you later?
No. If it was something you expected, or it was different, or.
It was great. I really liked it, and I appreciate it, and it was wonderful. So thank you for your time. Thank you for organization.
So is it, the content was what you expected and wanted?
Yeah,
okay.
I was interested in the topic, so I didn't really care about those specific parts. I just was interested in the topic, like in a broad sense. So.
Okay.
So how I said to Professor before, I like this type of teaching, you know, to combination the theoretical and especially the practice type of teaching, and I think it's great topic and great type of methods of teaching. So thank you.
So if you have anything bad to say, you can say it after I'm gone. No one's going to say anything bad while I'm sitting here. I understand.
My fault, because you know the information about the workshop was not good. Maybe.
Oh, okay.
We will not meet.
All right. Well, that I don't know.
Expectations. So that's what I'm.
I see. Okay.
Well, I absolutely agree with my colleague. It was great, and I think it did correspond to the program. But anyway, I liked everything.
So I wasn't here yesterday, unfortunately, but I really liked the program, and I also agree that it corresponds to the information.
Yeah, it was exactly what I expected.
Okay.
Yeah. Expected mostly to devise some toolbox with tools how to teach, and it was perfectly met. Thank you.
Yeah, I agree absolutely. I have many new ideas, and I like it very much.
Great.
Well, it was very interesting, mostly the practical demonstrations. Thank you.
All right, so I'm satisfied.
Thank you all. Thank you all very much.
Excellent.
Thank you.